in the objects.
How many of you are there?
My lord, only one petitioner.
Okay.
One petitioner. The number of posts, my lord, advertised for the lecturer in the obstetrics and gynecology department is 5 million. My lord, in this 5, the reserved category is also there. One for the ST and one for the, my lord, OBC and MOBC.
You're a general category.
I am a general category
Okay.
candidate, my lord. So for the general open category, 3 posts, my lord. Now, my lord,
Okay.
responding to these advertisements, my lord, I did apply, but before that, my lord, may kindly turn to page 27, my lord.
Yes.
Page 27 is the how the, my lord, recruitment process is required to be carried out. In the advertisement itself, the rule of the game has been set into motion, my lord. That is the written test public interview. If the number of applications received is large, the commission may shortlist the number of candidates either on the basis of their marks obtained in the qualifying academic examination required for the post in terms of advertisement, or by holding screening test, multiple choice objective type written examination, which will be notified in due course. So, my lord, if the candidate is large, then, my lord, they will calculate the academic marks, or, my lord, if the candidate is less, then, my lord, that or option they can adopt, my lord. Now, my lord, responding to this advertisement, I did apply, and, my lord, and call letter had also been issued at page 28, Annex 3, my lord. On 3rd of July 2015, I did appear, my lord.
It was scheduled on 3rd of
My
July.
lord, yes, my lord, the schedule for the interview has been given, my lord. 5/9, my lord.
The 3rd of July, what was 3rd of July?
No, my lord, the 3rd of July was the advertisement has been referred in the, my lord, this call letter at page 28.
Call letter is dated?
Call letter dated, my lord, 30th of August 2016, my lord.
38.
My lord. And this interview had been fixed, my lord. Viva was the interview on 5/9/2016, my lord, which shall be held in the office of the Public Service Commission, Joharnagar, Khanapara, Guwahati, 22. Now, my lord, responding to the same, I did, my lord, appear in the interview, and, my lord, ultimately, my lord, the result had been declared. My lord, may be pleased to find the result sheet is at page 32, Annex 5, my lord. 32, my lord, the last page of my petition, my lord. My lord, in this table, my lord, table number 2 is the declared result of the lecturer in obstetrics and gynecology department, wherein, my lord can be seen, my lord, that the general category has been shown as the one female, and rest STP, 2 STP, 1 OBC, and the other one is also STP, my lord. Now, my lord, from the affidavit, my lord, we have come to know that this person, my lord, had been selected on merit, not as a reserved category candidate, although their caste has been mentioned herein. So, my lord, there is no violation. Initially, my lord, we have pleaded in our writ petition that there is a violation of the, my lord, reservation law, which has acceded to the advertised category, my lord. But in fact, when, my lord, we have received the affidavit, we have come to know, my lord, no, our that plea is not, my lord, sustainable, because these all belongs to, my lord, the general category, although they have marked in the general category more than the, my lord, reserved category. So they have been included as a general category candidate. Now, my lord, the question of our challenge only stick to an affidavit filed by the Assam Public Service Commission, my lord.
Yes.
I beg to draw my lordship's precious attention to one of the paragraph of the affidavit, my lord, is at page 2. Running page is not here, my lord, but the page 2 of the affidavit, my lord, the internal page, my lord. Paragraph 2, my lord. May I read over, my lord, the relevant paragraph?
Just a minute, please.
My lord. Internal still to running page. 34, my lord. Running page is 34, my lord.
Yes.
My lord, paragraph 2, that before traversing through the various paragraphs of the writ petition, the deponent begs to address the core issues as follows, as below. In this regard, the deponent begs to state that as per the clause C of the advertisement dated 3/7/2015.
Now, what is the point you're trying to make?
Milord, a point we are trying to make.
One
Milord,
point you have considered that, yes, though they are the vacancy earmark for general category appears to have been violated,
by,
but in the affidavit, they have said that the reserve category candidate could compete with the general category,
category.
securing more marks, so they are regarded
Object.
as merit,
So,
as an unreserved category.
unreserved.
Matter one controversy ends there.
Yes, yes,
What is
Milord.
the controversy?
Yes,
existing?
Milord. The second controversy is regarding the condition
Hmm.
of the advertisement, Milord, which they have put forward in the page. My lord, I have already brought my lordship.
Page 27.
Page 27, Milord.
The options, two options.
Yes, Milord. Two options. They have not adopted to a single option only, Milord. They have adopted only to viva voce and finish up the process and publish the select list, which is in total violation of these two conditions, Milord. My lord, may kindly appreciate the condition which has been given written test public interview. Now the stroke interview they have interpreted in such a manner, Milord, that the only viva voce is sufficient, which is actually, Milord, they are required to read as a whole the entire part of the clause C, Milord. My lord, may kindly peruse that the commission may shortlist the number of candidates either on the basis of their marks obtained in the qualifying academic examination required for the post in terms of advertisement, or, Milord, if, Milord, the number does not exist, exceed more, then, Milord, they can, by holding screening test, multiple choice objective type written examination, which will be notified in due course. So not a single options they have adopted, Milord. Only interview has been called for. Viva was the
How
exam.
many candidates had applied
16, Milord.
in this post? Is it a large number of candidates?
No, Milord. It is not a large number.
All are invited.
Exactly, Milord. It is not a large
So
number.
what is the condition precedent?
Condition second will come.
No, not second. What is the condition precedent for either of the options?
Either of the option, the first condition, Milord.
No. What is the precondition? These are the methods that have to be adopted.
Milord, if
Precondition is that if the number
number
of
of applications
applications
received
received
is
is large.
large, Milord.
16, is it large in today's context?
Post 5.
No, Milord,
No, 5 posts can be 1,000 candidates,
my lord.
Yes.
depending on the
ratio, yeah.
candidates.
No, yes, depending on the,
There
we
is
have
16
to
number
call
of
on basis of
candidates.
ratio. If 5 posts, 1:5. So it is less than, my lord, that's why all are invited, my lord.
No, Milord, with all respect and my humble submission, Milord, from my limited
No,
understanding.
had it been a case that there were 500, 600, 1,000 candidates,
My lord, that is
then
also,
going
that is also,
for, see
My
the entire, these two options,
My
both are
lord.
optional or.
or me.
And what both the options are to be exercised
If.
on a precondition, if the number of applications received is large.
That is
You
correct.
may still contend that large is a vague expression.
Large
it
now,
is-
my lord, what constitute is a
Large,
large?
it's a vague expression, even
My-
16 may be large.
My lord,
But today's context of public employment,
public
16
employment.
candidates applying for 5 posts,
My lord, my lord.
is it such a large number that?
But my lord, may kindly appreciate another thing, my lord, that if there is no other options available for them, my lord.
What no other option? They have sent interview, written test.
No, interview is a part of these two, my lord. Interview means
no,
the
no,
only
no.
viva voce is not the interpretation,
No,
my
no,
lord.
no. Then what is your interpretation? Tell us.
Out of these two,
Tell
Milord,
us.
they could
No,
have
these two
opted.
will come only when there are large number. I think you should concentrate and reserve your energy for a better cases. Okay, we close this.
My lord.
Anything, Mr.
My lord,
Mon-
I have clearly mentioned, my lord.
Yes, anything, Mr. Bora? Okay.
Close 27, 28, my lord.
Yes, if the reservation was violated, then you could have had a case.
Yes, my lord, then
And-
merit, my lord.
They have selected on
My-
merit, my lord. My lord, I have to submit fairly before my lord.
Yes, correct, my lord. He is.
No, you are always.
In fact, he mentioned the, that citation also.
My lord, my lord.
Okay. Please have your seat, please.
My lord.
The controversy raised in this petition filed under Article 226 of the Constitution of India is in connection with a recruitment process initiated by the Assam Public Service Commission, within bracket APSC, for different posts of lecturers in the nursing colleges of Assam. Full stop. The petitioner has structured his petition on two principal grounds. Firstly, violation of the reservation policy, and secondly, the mode adopted for such selection. Full stop. Para. I've heard Sri A.R. Bhuya, learned counsel for the petitioner. Full stop. I have also heard Sri T.J. Mahanta, learned senior counsel, assisted by Sri P.P. Datta, learned counsel for the APSC, and Sri D.P. Bora, learned standing counsel, Health and Family Welfare Department. Full stop. Para. By drawing the attention of this court to the advertisement dated 3/7/2016, comma, the learned counsel has submitted that amongst the various posts advertised, comma, there were 5 numbers of posts of lecturer in the O and G department for which the petitioner had applied. Full stop. Out of the 5 vacancies, comma, 3 were for unreserved category and 2 for reserved category. Full stop. It is not in dispute that the petitioner belongs to the unreserved category. Full stop. The petitioner, on her application, was issued a call letter on 30/8/2016, and the interview was scheduled on 5/9/2016, in which the petitioner had appeared. Full stop. However, in the results published, comma, the petitioner was not amongst the selected candidates. Full stop. Para. Sri Bhuya, the learned counsel, has submitted that the communication towards declaration of the results dated 24/3/2017 would indicate that only one general category candidate has been selected for appointment as lecturer in O&G department, and the 4 other vacancies have been filled up by reserve category candidate. Full stop. The learned counsel has, however, fairly submitted that from the affidavit in opposition filed by the APSC, comma, it transpires that 2 of the selected candidates who belong to reserve category candidate have been treated as general category, as unreserved category on account of their merit. Full stop. He therefore contends that he would not press upon the said ground of challenge. Full stop. Para. Sri Bhuya, the learned counsel, however, has strenuously canvassed that the procedure adopted for selection is not in terms of the stipulations made in the advertisement, full stop. By referring to the mode indicated in the advertisement, comma, it is submitted that selection was to be held by written test oblique interview. And it stipulates that the commission may shortlist the candidates either on the basis of the marks obtained in the qualifying academic examination required for the post in question, or by holding screening test within bracket multiple choice objective type written examination, which would be notified, full stop. It is submitted that none of the procedures were adopted, and only on the basis of viva voce, comma, the selection has been done, which is not as per the mode indicated in the advertisement, full stop. The learned counsel accordingly submits that the selection is to be interfered with and the candidature of the petitioner be considered in proper perspective, full stop. Para. Sri Mahanta, the learned senior counsel for the APSC, however, has submitted that even the existing ground of challenge is both factually and legally untenable, full stop. He submits that the interpretation of the mode given on behalf of the petitioner is not correct, full stop. It is submitted that under heading capital C, comma, the precondition for going for shortlisting the candidates on the basis of the marks obtained in the qualifying academic examination, or by holding a screening test, is that the number of applications received should be large, full stop. By drawing the attention of this court to the affidavit in opposition filed by the APSC on 6/1/2024, comma, the learned senior counsel has submitted that for the 5 numbers of vacancies, comma, the total vacancies in the post of lecturer ONZ, comma, the total number of applications received were 16, full stop. It is submitted that the said number of 16 is even less than the number which is envisaged for maintaining a ratio of 1:4, 1:6, full stop. It is accordingly submitted that there was no requirement for adopting either of the two modes for shortlisting, and the candidates were accordingly interviewed, based upon which the selection has been made, full stop. It is further submitted that the mode of selection as such by interview is not the subject matter of challenge, and the petitioner, as the petitioner had submitted to the said selection process without any objection. Full stop. Para. Sri, are you referring to the decision? J.N.K. Madan Lal? No.
Because he had that, or yes, that petition once appeared in the,
Yes, where?
Yes.
Madan Lal, Om Prakash.
yes, post my lord. I'll to judgment that is,
Om Prakash.
currently the, 2018-12 SCC 635. Another is my lord. Pradeep Kumar Rai.
You have not referred to the J.N.K. case, Madan Lal. Okay, doesn't matter. Sri, please give the decision.
Yes.
In support of his submission, comma, Sri Mahanta has relied upon the following two decisions. Please give the citation, Mr. Dutta.
but-
Para. Sri Bora, the learned standing counsel health department, while endorsing the submission made on behalf of the APSC, has further submitted that APSC is the statutory body through which the selections are made, and there does not appear that there has been any anomalies in the said selection. Full stop. He accordingly prays for dismissal of the writ petition. Full stop. Para. On consideration of the submissions and the materials placed on record, comma, this court has noted that the first ground regarding the allegation of violation of the reservation policy has appeared to be factually untenable in view of the facts projected in the affidavit in opposition, that 3 out of the reserve category candidates, that two out of the two candidates of reserve category has been appointed in the vacancy meant for unreserved category on the basis of their merits. Full stop. As regards the second ground, comma, it would be convenient if the relevant portion of the advertisement is extracted, is taken into consideration, which is extracted herein below, page 27, C. The aforesaid provision of the advertisement has clearly indicated the mode of selection as written test / interview. Full stop. The said heading further stipulates of two options in case two options of shortlisting the number of candidates on the basis of the marks obtained in the qualifying academic examination, or by holding screening test. Full stop. It is, however, to be noted that either of the two options are to be exercised only when the application received is large. Full stop. In the instant case, comma, admittedly, for 5 numbers of vacancies, comma, the total number of applications received is 16. Full stop. Therefore, comma, there was no requirement at all for adopting either of the two options, and accordingly, the candidates who had applied were subjected to a viva voce test. Full stop. The petitioner, having participated in the said selection process, in the mode adopted by the advertisement without any demur will not be allowed to challenge the mode, that too on a ground which apparently appears to be fallacious. Full stop. Para. This court is of the considered opinion that the grounds of challenge structured is both legally and factually untenable, and accordingly, the writ petition is dismissed.
Obliged.
Yeah, please, ma'am. Now, here the grievance of the petitioner is against the appeal medical board, which has rejected his candidature on the ground of fine tremors of his hands. What had happened is the petitioner was initially selected and appointed in the Assam Rifles, madam, in the
As
year as a rifleman general duty, rifleman barber,
barber,
madam. In the year two
When?
thousand one.
2001.
2001, madam. In the same year, my lord, they were, he along with several other persons, my lord, around 90 persons in total, they were all shunted out of the Assam Rifles on the ground of being
You were
medically
initially
unfit.
posted where?
My lord, I was there in Dimapur, my lord. I was sent for training to Assam Rifles Training Center and School at Dimapur.
Okay, then what
Then
happened?
during my training, my lord, in
Hmm.
October 2001 itself, they discharged me from service on the allegation that I was suffering from fine tremors of my hands.
Fine
Along
tremors.
fine tremors of my hands, but along with another about 90 personnel, my lord, who were found with different medical defects.
Okay.
We approached this honorable court, my lord, different persons filed different petition. One of them, my petition
No,
was
the other the disqualification or discharge were also on medical grounds,
on medical grounds, my lord, and
not
90%.
necessarily fine tremors.
Not
Other
necessarily,
grounds.
other grounds, my lord. Someone had a
Okay.
hearing impairment, someone had a vision problem. We all approached this honorable court by filing different writ petitions against the discharge. My writ petition was WPC 6721 of 2005.
67
21 of 2005
by petitioner.
by the petitioner, madam. This came to be disposed of on 10/8/2012.
Page
Madam, that order lordship would find at page 44 onwards.
44.
44, madam. Several writ petitions were disposed of together, one of them being mine. I'm sorry, madam, that is not page 44, madam, that is, it starts at page 19.
Hmm?
16, it starts at page 16, madam, that order states, starts at page 16.
16.
16, madam.
Yes.
But in that matter, if lordship has page,
What is your name?
madam, my name is
6721.
Sahab Singh, my lord. Lordship would
Which
find
page?
me at
Which page? 6721.
yes, my lord, at page 25 is my seat number, my lord, in the middle, Sahab Singh.
Okay.
At page 30 is the relevant book. Page 30, my lord. The middle portion, lordship will find a date 10/6/2010 is quoted below. without expressing any opinion on the merit of the case of the petitioners, all the petitions are disposed of with the direction. Page 30, my lord, 30.
30, which part, page?
Middle part, my lord, lordship will
Without
find
expressing.
a
That
date,
was the earlier part.
my lord.
Opportunity, there's a quotation.
Yes, ma'am, there is a quotation of the similar repetitions which are disposed. And then lordship is held that this batch of repetition is also disposed of in terms of the above order.
Okay.
Therefore, I was
Yes, so what was the direction to constitute?
without expressing any opinion on
To
the merit of the
constitute,
case
to
of the petition.
constitute,
Yes, madam.
to
Constitute a
constitute.
fresh appellate medical board comprising of at least one doctor having expertise in the field, in the particular field of disability. Each person's disability was to be assessed separately by specialist of that field in which he was found to be.
Okay.
In compliance thereof, my lord, at page 33, annexure 4,
3.
33, my lord. They called me for my appeal medical board, and this is the finding at paragraph 1. You were
27,
enrolled in Assam Rifles on
27,
27th,
12,
my lord,
27, 12.
27th of December 2012, my lord.
Yes. What appeal, findings of the appeal medical board?
On the second paragraph, my lord.
Findings of the appeal medical board?
Yes, my lord. Appeal medical board examination.
Okay. Second paragraph.
Para
Yes.
number 2. In compliance of the Honorable Guwahati High Court order.
You found unfit.
Found unfit in relation to the above mentioned capacity. Incapacity. Now, this is what is under challenge, my lord.
You have been found unfit.
I have been found unfit.
Okay.
And they have taken 2 grounds. Lordship will find that para number 4. Para number 4. Considering the above facts, it has been decided by the appropriate authority, your case of enrollment against the existing enrollment policy cannot be considered due to your medical incapacity and overage. This overage factor has been considered by this honorable court in a batch of repetitions, which was initially dismissed. We went up in appeal. That lordship would find at page 53. The orders passed in the appeal. Relevant portion lordship would find at page 59. It starts at page 53.
What starts?
Read appeal, page 53, annexus 7. Read appeal 153 of 2014.
Writ appeal. This is WPC.
My lord, that was wrongly printed, my lord. It is read appeal 153 of 14, my lord.
Not
Not WPC. My lord. WPC was
not 735.
my lord, no. It is read appeal 153 of 2014. There, the relevant portion lordship should find at page 59. Nine, my lord. Para 14. The impugned order dated 27/12/2012 itself indicates that the petitioners were enrolled into Assam Rifles. They were found to be unfit during final medical examination and consequently discharged from the Assam Rifles before completion of the necessary basic training. It is also very significant to note that all the petitioners who have been found unfit by the authority in the Assam Rifles have been found fit by the appeal medical board. The discharge orders of the petitioners were issued as they have been found medically unfit. Now the appeal medical board, having found the petitioners medically fit, the very foundation of the discharge orders must survive and exist, and as such, the petitioners must be deemed to be in enrollment of the Assam Rifle, and as a corollary, they must be afforded the opportunity to undergo and complete the basic necessary basic training which they had been undergoing before their discharge. If they can successfully complete the training, they must be appointed to their respective posts. So their ground of overreach was set aside by this honorable court for the persons who were found to be medically fit.
Yes.
So that even in my case, in the discharge order, when the ground of overage has to go because of the judgment which has said that overage cannot be a ground. Now, my lord, the ground on which I have been declared to be medically incapacity, to be suffering from medical incapacity. Lordship should kindly take up Lordship's order dated 15/9/2021.
Please.
My lord, lordship, order in this writ petition itself, my lord.
15,
15/9/2021.
yes.
Ms. So-and-so to obtain instructions as to whether at any stage of the proceedings, the petitioner was medically examined by neurologist as the ground declaring him unfit appears to be a neurological problem. This finds support, my lord. This was done. Lordship will find at page 36 of their affidavit in opposition.
30,
6 of their affidavit in opposition. Lordship may have page from 34 onwards, my lord. This was the SOP which existed when I was discharged from service. 34 of the affidavit in opposition.
just a minute.
Page 34 is the SOP of 1997.
Yes,
Lordship will find page 34 is the SOP. Page 35, my lord, is the educational and technical qualification. Page 36 in the middle, Lordship will find the grounds of rejection on medical grounds.
is,
36, my lord.
Hmm.
Serial number 21H.
yes,
Mental and nervous instability includes coarse digital tremors. This digital tremor is related to mental and nervous instability, and therefore, by order, my lord, which I had pointed out at 15/9/2021, Lordship said that whether he was at all placed before a neurologist.
yes,
Now, my lord, in the same affidavit in opposition, if Lordship will have page 33,
yes.
this Lordship will find is a referral form for the Medical Appeal Board, Assam Rifles.
Hmm.
Below serial number 5, at serial number 5, Lordship will find the identification mark and it is dated 3/10/2012.
Hmm.
Just below that, Lordship will find to be completed by specialist unfit, and the seal and signature near the countersigned is, my lord, one of a specialist.
Yes,
So, my lord, he was not placed before a neurologist as required by the earlier order of the
specialist, what is this
medicine. It is not of neurology. Now, my lord, to stress on the point that I should have been placed before a neurologist, before they could have rejected me, this is a letter
Yes,
this is a later SOP guideline in 2015, which they have developed. If Lordship will kindly have the page 10 serial number T. Page 10 serial number P, Lordship will find tremors without any organic cause. So the whole issue is before Lordship today is that whether my candidature could have been rejected in the way it was without referring me to a neurologist or without taking into account the fact that it could have been a minor acceptable defect also. Well, for the other bunch of repetitioners who had approached this court under such circumstances, I'll just place one order of Lordships, my lord. The manner in which the medical tests were done Take it up. Give me one by one. And here lordship will find the judgment, the orders, lordship order.
Yes.
Lordship's order dated 22/6/2022.
Hmm.
Here also, my lord, all these persons, they had undergone medical on the same day, along with the petitioner, the review appeal board. The second paragraph, lordship will find, third paragraph, the petitioner is aggrieved by an order dated 27/12/2012 by which he has been rejected from his services in the Assam Rifle on the ground of medical incapacity and overage. Medical incapacity was urged by the petitioner not to be a ground of discharge, and in this regard, the petitioner, along with others, had approached this court by way of various petitions filed, which was disposed of on 10/8/12. The aforesaid bunch of petitions were disposed of, remanding the matters to the authorities to re-examine the medical status of the incumbents, including the petitioner. It is a specific case of the petitioner that after such remand, through wide report dated 3/10/12, which has been held to be unfit with the remark that the specialist opinion is enclosed, such specialist opinion is of a later date, that is of 5/10/2012. Sri Mazumdar so-and-so submits that the entire basis of holding the petition to be unfit on medical ground being a specialist report, such report ought to have been there before making the said remark and cannot be supplemented by a report of a later date. Respondents have filed their affidavit in opposition where the communication concerning the dispute has also been annexed. This court has specifically directed the learned CTSC to obtain instructions from the issue which has fallen for determination, and upon receipt of the instructions, learned CTSC has submitted that the instructions received are in consonance with the annexure of the petition, more specifically those dated in the report dated 3/10 and the specialist opinion dated 5/10. That being the position, this court is not required to undergo the other aspects of the challenge, in as much as the impugned action appears to be arbitrary and accordingly held to be unsustainable in law. In that view of the matter, the impugned order is set aside and petitioner is right to be inducted in the service of any constable under the Assam Rifle, and the authorities are, however, at liberty to have created medical review of the petitioner. Now, here, what I would today pray is, Lordship's order in 2021, Lordship should find several orders after that in this particular petition itself, where they have taken time for instructions. They have not been able to show that there was a neurologist in the board. Today, my lord, all I would pray is set aside this rejection, send me before a neurologist, let him say I'm unfit, I go home, let him say I'm fit, my lord, I get my chance to complete my basic training. Based on orders, my lord, there are several other orders, my lord, where this 3/10 and 5/10, that discrepancy, it has happened in case of each and every petitioner. In our case, my lord, they have not produced the specialist opinion, though it was asked for in 2021. They have not made it.
No, other cases in the review medical board, they are found to be fit.
No, my lord,
In spite of that, because of the age factor, they were not given.
my lord, this case which I have placed before lordship, my lord.
This case, there is a medical specialist opinion only because it's post-dated. We have
Yes.
said that you cannot depend on a.
In
Here, can you just go to the intricacies of this specialist not being from the Department of Neurology?
my lord, therefore, my lord, that is why in the original order, my lord, in the original order itself, this honorable court had observed that it has to be by the specialist in the particular field. That was the observation. Even in this case, lordship will find that the specialist opinion was taken after the rejection had come. In
No,
every
no,
of the cases,
after the remand,
my lord,
your appellate medical board has come to a finding of unfit.
that unfit has come from a medical, from a specialist medicine, not from a specialist in the field.
Can you go into intricacies?
My lord, that
It's
is,
it's a appellate medical board.
that appellate medical board has to constitute of a specialist. My lord, it is also the judgment of several orders of this honorable court, my lord, right from the year around 2007-8, my lord. There are several judgments, if I'm allowed to place, my lord, that it has to be on that particular field, a specialist has to be there. It cannot be by someone else.
It's by a board.
It is not by the board, my lord, lordship will find.
Hmm?
They call it a board, but there is only one specialist, lordship will find at page 33. There's only one doctor. And he's from medicine. If the board had one doctor, my lord, which had any knowledge, or if you could declare me unfit on that ground, my lord, especially based on the orders passed by this honorable court earlier at page 33.
There are other signatures. The signature of the medicine.
Page 32 lordship.
Page
This
33.
is the board.
This is
the
for
board, lordship.
every of the petitioner. This is the finding. Lordship will find at page 29 onwards. It is just a referral that these are what each petitioner has got. for the specialist opinion. Lordship will find page 29, appeal medical board proceeding in respect of so and so of others who were discharged on medical ground is resubmitted herewith along with specialist referral form and connected document. There is no document connected for the present petitioner to show that any test was done on him, any findings are there. Their guidelines say that it can be a coarse digital tremor, which has to be related to mental or mental instability. Later on, documents say that there has to be some organic cause found. Nothing done, my lord. Simply a man, even if we assume that there was a tremor in the hand, facing a medical board, my lord, a man may tremble. It has to have some organic cause, some relation to his something where he can be rejected. That is even a minor acceptable defect as I played before.
Mr. Mazumdar, come to page 30,
Page 30, my lord, yes.
that chart, the table.
Yes, my lord.
Okay, you just for illustration's sake, serial number 1,
Yes,
Sajjan
ma'am.
Kumar.
Yes, my lord.
His reasons for earlier rejection was what? Fine, digital
Digital tremor.
tremors.
True, my lord.
But still he has been held to be fit.
He has been helped with
It is not a case that
he-
they do it mechanically.
he did not tremble that day, perhaps.
No, it's not, we can't go on. we're
But
not
lordship
count-
will- if
we
lordship
cannot
will
go on
kindly-
speculation on a particular day, what had happened, what had not happened.
If lordship
They
will
have
can-
done an objective test
if lordship will
by
kindly
a
have-
board. It's not the
Serial
case
number
that
4,
all
madam.
have been held to be unfit. There are
Madam.
some instances where appellate medical board has changed its decision
Yes, ma'am.
from unfit to fit.
True.
There are many decisions.
My lord, lordship will find at serial number 4, my lord.
Now, can
This
we go
particular
on and
Santa-
on?
Lordship will find, my
See
lord,
at serial number 13, fine tremors, both hands, but fit. Serial number 13 at page 31,
yes, my lord, he's there. But then
fit.
lordship will have another.
Tremors, both hand at page 8, serial number 18, Sadhu Kumar, Sadhu Ram,
Okay.
fit.
But what I'm trying to emphasize is if lordship will have serial number 4 for a moment, serial number 4.
4, yes. Santlal,
Santlal, he was found unfit.
yes.
This honorable court directed a remedial examination, my lord. He is now inside, he is now doing his training. They found him fit. The specialist found him fit.
Santlal, what
My lord,
decision?
Santlal decision I had.
What was the decision in Santlal?
My lord, in Santlal, they had given,
Santlal was only for age.
no, my lord. Santlal was for medical incapacity. Medical incapacity. Here they had given a specialist opinion again of 510. This honorable court said, no, do it by a specialist properly.
No,
Because
that,
Here we don't even have a specialist opinion. All these cases, my lord, all these cases, 310 is the report, 510 is a specialist report, lordship will find. Santlal, lordship
no,
will find.
that is a different aspect. That the specialist report came on a later point of
What I'm
time.
trying to emphasize is, my
This
lord,
will not apply to you.
that they have not even given the specialist report. That is the whole issue, my lord. They have not been able to produce the specialist report. It is a simple word, unfit. There is no report annexed from 2021 when this honorable court wanted them to find, just to make that statement, whether there was a specialist. In every case, it is 310 and 510. Here they have not given the report. I have not been able to point out that mistake. Or if lordship will give them one opportunity to bring that report of the specialist on board, my lord, if it is on the same day.
Santlal and Sadbir Singh are distinguishable on facts.
My lord, that,
The
because
review medical board has given a finding, and based on that, and thereafter that finding, some other report has come which is post-dated.
I
You are-
submitted that, my lord, I could point out those reports, later on reports, because they had annexed it to the affidavit in opposition.
How can you contend that for you some other treatment was given and for the others some other treatments? The others have been found to be fit by the same board. There is no
if lordship will-
malafide here.
Lordship will only.
They want the person who
Madam,
are
if-
fit to be inducted in the service. These are some rifleman post.
What I was trying to emphasize, my lord, is that for every other person, they have got the specialist report on record. Lordship will just ask them to bring the specialist report on record, my lord. If it is of a later date, my lord, I get completely covered. Even otherwise, if there is no specialist report, that would be the very ground, my lord, for them to go for a review by a specialist medical board. Once that rejection comes, my lord, everything goes. And if the specialist
Can you
medical,
stretch it? Yes, we may have mentioned in our order regarding requirement of a neurologist. But
Madam.
can you stretch it to that? The signatory says he's a specialist in medicine.
medicine, my lord.
And it's a fitness test. It is not a
Otherwise-
test which will go into the entire intricacies of
Madam-
your detailed medical test of your blood and
not necessarily.
It's only
At least-
because of the problem which you have been found.
Even my
Tremor.
lord, they admit,
Other persons with tremors have been found fit,
Madam-
some are found to be unfit. You are
my
amongst
lord,
the unfit.
even there, my lord, even there.
Yes, madam.
Lordship, this is a 2001 case and he was not appointed lordship. He was provisionally enrolled lordship
Same.
subject to confirmatory medical board examination lordship. In the confirmatory medical examination, he was found unfit. And as per the order of this honorable court lordship, he was, the appeal medical board examined him and found him unfit. And there, the lordship, after 5 years of his appeal medical board examination lordship, he approached this honorable 2012 appeal medical court was held. In 2017 he approached the and again also lordship Now-
Petition filed when?
2017
17.
appeal medical court was held in 2012 lordship.
And in all the cases, my lord, it was 12 and 17 because the persons, my lord, none of them are available in Guwahati. They are all from outside the state. Reports did not reach them on time.
Is it
Where have
2001?
you stated?
My lord, yes, I have to say that.
How will you explain the delay?
My lord, that has been, my lord.
And also lordship, he is now 45 years old. And,
And at paragraph 12, my lord, they were told that once the appeal comes out, my lord,
Where?
that-
What?
at paragraph 12, my lord.
Yes, what have you stated?
Paragraph 12 was stated and paragraph 20, my lord.
What have you stated?
Paragraph
Read.
20, my lord. I'm sorry.
Yes, please read.
Paragraph 20, my lord. Page 11.
Yes, please read.
That the repetition basically stated there is no willful delay to prefer the repetition as the issue involved against the impugned order is was settled in the month of October 2014. The petitioner further basically stated that September 16, the authority informed the repetitioner that the respondent authority had restricted the benefit of the order to read appeal only to the appellant. The repetitioner further basically stated the repetitioner is a resident of Matloda from Haryana and had to make arrangements for visiting council at Guwahati, which not only involves journey of 3 days but also a stay of 3 days as well as heavy expenditure. Due to the prior commitments and engagement with his living and earning, it had to be arranged before he could come away for enabling his works and litigation in Guwahati. It is relevant to point out that only after making arrangements, the petitioner could hand over the relevant documents to file the writ petition before the honorable court. He took some time to the counsel of the writ petitioner to prepare the case, and after verifying the pleadings and above referred writ petition has been filed. As such, there is no willful and negligence on the part of the petitioner, my lord. In fact, the petitioner, my lord, he has, when I had asked him if he had given me, that was part on my mistake, my lord. His daughter was suffering from severe ear diseases for which he had been running around in the in that place also. Lordship may like to go through this, my lord. Yes, the below property line and my lord the condition of his daughter, my lord, which prevented him from coming to the honorable court.
Which paragraph did you read for delay
Para 20, my lord,
of?
page 11 of the writ petition. All the other persons, my lord, they were also rejected in 2012, approached this court in 16, 17 and appealed granted the relief.
They were found to be medically fit.
No, my lord, the orders which have given, they have found to be medically unfit, my lord. All unfit people, they have approached,
But medically found unfit based on a report which is post-dated.
my lord, same report, same date, 3/10/2012.
Based on a report of a new specialist which is post-dated.
Post-dated, my lord. Here they have not given us the copy of the report. That is why I have not been able to point out that particular date, that it will also be 5/10/2012. It cannot be before that, my lord. That is how they have handled every case. If lordship will have all these judgments, my lord, I can give around 6 writ petitions, my lord, where this every report is 5/10/2012. All reports were prepared post-dated when we took up the ground. When we took up the ground of a medical report, the specialist not being there, the specialist find I have given. Sorry.
What is the statement regarding delay has already been denied lordship in our affidavit. He has never approved the authorities. Or neither
Yes.
the authorities have given any assurance to wait for him for.
These two petitions of lordship will find the same post-dated reports had been produced before this court. In this particular case, they have not come up with the report. Therefore, I'm not being able to emphasize on the basis of record. Every case it is 310 and 510 or 1210.
All these cases, there were specialist report which are post dated. That is the only consideration.
And yes, in this particular case, they have not produced the specialist report. Therefore, I'm not being able to place that on that before lordship. And therefore, on the last 3 occasions, they were required to place the specialist report.
Is there a specialist report?
That comes up, my
He was
lord.
examining the composite hospital ESF lordship by a specialist medical professional lordship. It is not
report has to be
mentioned lordship, any specialist on this neurology or any other. But it is.
Yeah,
in
immediate
our
position is there is no
affidavit-
specialist, then the original order is being violated. All I'm praying is for a specialist.
And in the original order also, lordship, it was specifically stated that there, if they were found, if they are found, lordship, fit, in that case also, their age criteria will also be considered.
Which has been done away with by the repealed order.
Because he is now 45 years, lordship, and age criteria comes second, lordship. First, he is not fit. And
Immediate
medical,
position is there is no
medical-
specialist doctor, my
medical-
lord. That is my only case.
it is a fine tremor, lordship. No such specialist doctor is required, I think.
Now, vis-a-vis
board-
their own guidelines saying that it has to be related to a mental or a mental instability.
Not
That is their own guideline. They have annexed it.
including lordship. Is stated that
So it is only when it is mental or nerval instability to include digital tremor. That is also coarse, not even fine. Fine tremor is not even a ground to discharge.
each case is separate, lordship. One case cannot be the ground of considering the other. Someone find someone fit, someone not fit.
It is for the post of barber.
He was enrolled as competent, lordship.
No, as a barber.
Yes, as per my affidavit, lordship, he was
Can
enrolled as competent, and for competent, he needs
can
to
he?
handle the lordship weapons. And for this, his fitness is sure.
Certificate of discharge says I am a barber.
Yes, barber,
And this
competent,
barber is the competent.
yes.
Okay, we'll consider. Heard. Three. R. Madandar. Learned Counsel. For the petition. Also heard. Miss R. Devi. Learned CGC. Full stop. Para. the present case has a checkered history and bereft of the details, the necessary facts which are required to be taken into consideration are narrated herein below. Full stop. The petitioner, the facts projected in the petition, please have your seat, is that he was appointed as a rifleman.
As a
In-
recruity barber, man.
Not rifleman,
Well, they say recruity barber. After the basic training, he becomes
as a recruity barber
Hmm.
in the Assam Rifles in the year 2001 and was sent for training to Dimapur. Full stop. However, in October 2001, he was discharged from his service along with about 90 other persons on medical grounds. Full stop. The grounds assigned, so far as the petitioner is concerned, is fine tremors of the hands. Full stop. The aforesaid orders of discharge were the subject matter of challenge in a number of writ petitions, including WPC 6721/2005, filed by the petitioner. Full stop. The aforesaid writ petitions were disposed of by this court by the order dated 10/8/2012, whereby a fresh appellate medical board was directed to be constituted. Full stop. The court, however, made it clear that no observation was made on the merits, on the inter se merits. Full stop. Subsequent thereto, an appellate medical board was constituted which examined the petitioner and vide a communication dated 27/12/2012, the petitioner has been held to be unfit. Full stop. The petitioner has also brought on record an order dated 29/9/2014, passed by a division bench in a number of writ appeals, including writ appeal 153 of 2014, wherein the matters were remanded for fresh consideration on the ground that those incumbents were held to be medically fit, they were not reinducted in the service on the ground of overage. Full stop. Para. Shri Mazumdar, the learned counsel for the petitioner, has submitted that though the petitioner in the present case has been held to be unfit, such decision is not preceded by a due process recognized by law. Full stop. It is submitted that the admitted ground of discharge on medical fitness is that the petitioner was having fine tremors of the hands. Full stop. The learned counsel, by referring to this SOP, which has been annexed to the affidavit in opposition of the respondents, has submitted that the aforesaid ground can be related to the ground under serial H, which is with regard to mental and nervous instability. Full stop. Reference has also been made to an order dated 15/9/2021 passed in this case, wherein the aspect of a requirement of examination by a specialist, within bracket neurologist, in the case of the petitioner was made. Full stop. By referring to the note wherein the petitioner has been held to be unfit, comma, the learned counsel for the petitioner has highlighted that the board was not having any neurologist as a specialist, and the specialist whose name and signature appears is of medicine. Full stop. Reference has also been made to the present SOP, as per which tremors without organic cause has been declared to be minor acceptable defects. Full stop. The para. Sri Mazumdar has also placed before this court copies of a number of orders passed in similarly situated cases, wherein relief were granted to the incumbents with the liberty to hold fresh medical examination of those incumbents. Full stop. Para. Per contra, comma, Ms. RDB, learned CGC, has submitted that the initial induction of the petitioner was on the condition that he should be medically fit. Full stop. When it was detected during the time of training that the petitioner was not medically fit, comma, he was discharged from his service in October 2001.
31st October.
October 2001. Full stop. The earlier round of litigation instituted by the petitioner, YWPC 6721 of 2005, which required a re-examination by a fresh appellate medical board, was done, upon which the petitioner was found to be unfit. Full stop. The learned CGC has submitted that there is a vast distinction on facts regarding the present case and the cases cited by the petitioner, inasmuch as in those cases either the incumbents were found fit but were not allowed to join on the ground of overage or and in few cases, comma, the declaration to hold the incumbents unfit were followed by the report of a specialist, full stop. She submits that in the instant case, none of the two conditions are available for the petitioner, as he was found ineligible both in terms of being overaged and unfit. Full stop. The learned CGC has also highlighted the aspect of delay in approaching the court, in as much as the writ petition was filed in the year 2017
Seven.
on a cause of action which had arisen in 2012. Full stop. Para. Sri Mazumdar, the learned counsel for the petitioner, in his rejoinder has submitted that the order passed by the division bench dated 29/9/2014 is only on the aspect to take care of the situation of being overaged. Full stop. He clarifies that the present petition has made an independent challenge on the findings of the appellate medical board to term the petitioner as unfit. Full stop. As regards the delay, objection regarding the delay, comma, he submits that appropriate explanations have been given to explain the delay in paragraph 20 of the writ petition. Full stop. Para. The rival's submissions have been duly considered and the materials, no? Full stop. Para. The full stop. Para. The principal, and at the outset, comma, let this court deal with the aspect of the objection of delay in approaching this court. Full stop. This court is a court of equity, and the conduct of the parties is of paramount importance, and delay latches in approaching this court is a relevant factor. Full stop. In the instant case, comma, the cause of action had arisen in the year 2012, and admittedly, the writ petition has been filed in 2017. Full stop. Though there may not be a strict application of the Limitation Act 1963 in a writ proceedings, comma, the aspect of latches would always be there and would be a relevant factor for consideration. Full stop. The explanation given by the petitioner in paragraph 20 are not found to be cogent and acceptable. Full stop. Having said that, comma, this petition was filed in the year 2017 and is being considered after about 7 years. and rejection of the petition on the ground of delay without going into the merits after 7 years of the same same being pending, pending would not be a fair treatment. Full stop. Accordingly, though a case for of delay was made, appears to have been made out, this court, in the interest of justice, would overlook the said aspect. Full stop. Para. The challenge is with regard to the findings of the Appellate Medical Board dated 27/12/2012, which has declared the petitioner to be unfit. Full stop. Though an objection with regard to the age has also been raised by the respondents, in view of the order dated 29/9/2014, passed by the Learned Division Bench, this court, the said objection would not be a sustainable objection. Full stop. As regards the remark of unfit, the primary contention is that the said findings were arrived at by a board without there being a specialist in the field of the medical, in the field of the particular reason assigned, namely fine tremors of hands. Full stop. The SOP which has been placed on record would show that the said cause can be related to the ground under serial number H2 bracketed, with inverted comma, mental and nervous instability, which would naturally require examination by a specialist neurologist. Full stop. The medical board, appellate medical board, though had a specialist, was on the aspect, on the field of medicine and not neurologist. Full stop. Para. As regards the case laws, as regards the orders of this court passed in similarly situated cases placed on record by the learned counsel for the petitioner, this court has, however, noticed that in those cases, the findings of holding the incumbents unfit were followed by a report of a specialist. Full stop. Though the facts of the present case are apparently distinguishable, what would, however, require is an opinion of a specialist, within bracket neurologist, so far as the medical unfitness of the petitioner is concerned, which admittedly does not appear to have been done from the records placed, from the materials placed on record. Full stop. Para. In view of the above, this court is of the considered opinion that interest of justice would be met if a direction of the following nature is given. Full stop. the case of the petitioner regarding his fitness be re-examined by a duly constituted review medical board, which is required to have one specialist in the field of neurology to examine the petitioner. Full stop. The findings of such a board would be final in view of the facts and circumstances that the aspect of medical fitness of the petitioner was already gone into by two medical boards earlier. Full stop. If the review medical board, as directed to be constituted, comes to a finding of the petitioner being medically fit, comma, the aspect of the age would not come into in view of the order passed by the Honorable Division Bench on 29/9/2014 in WA 153 of 2014. Full stop. However, full stop. With the aforesaid directions, comma, the writ petition stands disposed of.
I'm obliged.
এই কেইটা যে আছে, এইকেইটা এটা প্যারাগ্রাফত দেখিবা has Sri R. Mazumdar has referred to the following orders passed by this court, order dated হেৰি আৰু নাম তিনটা নে চাৰিটা আছে. This you can take it back, SOP. Item 5. Mr. Ganguly was here, A. Ganguly. Where is Mr. Ganguly? Miss R. Kulita, who is R. Kulita? Grameen Bank. What is the subject matter? None appears for the parties on call. Full stop. In the interest of justice, list after 2 weeks.
I read the matter relate to my lord disciplinary proceeding and punishment, my lord, for my lord punishment. One increment, my lord, withheld. My lord, so far, my lord, respondent is concerned. Respondent number 5 is the inquiry officer against him, my lord.
One increment simpliciter with cumulative effect.
No, without cumulative.
When was it done?
Without cumulative, my lord, page 43.
When was it done?
It was 25 September 2020.
23.
20.
20.
Yes.
Are you really pressing this?
My
Now you
lord,
have got back the increment.
my lord, so far the respondent number 5 inquiry officer, against him, my lord, I have serious allegation because he was not allow me to cross examination, my lord, and document also asked for not
What is the
apply.
charge?
Yes.
What is the charge? What post did you hold?
My
What
lord,
post did you hold?
my lord,
Or police?
police, sub-inspector of police, APRO. My
What
lord,
was the charge?
charge, my lord, insubordination.
So insubordination is a very general
Uh,
term. What did you do?
Insubordination, my lord, in fact, my lord, one file was, my lord, pension file was returned from the AG department, my lord,
Hmm.
because, my lord, for my lord, negligence of, my lord, the department, my lord, there was no gazetted officer, and, my lord, service record of the employees, my lord, not verified since 1886 to 2015. That is why AG returned the file. And, my lord, it was, my
Now see,
lord,
the increment, the penalty has spent its force. It's a holding of one increment with simplicity. After the completion of that year, you get back everything. There is nothing. If you're not very serious, you can withdraw this. If you are serious, we examine.
my lord,
But the punishment will not have any substantial effect on your
But
service
my lord,
unless
procedure-
you want to have a clean
procedure,
sheet.
my lord, my case is, my lord, complete denial of the charges, my lord. That is why, my lord, I should, my lord, you have given, my lord, the chance of cross-examination, my lord. And, my lord, these are main persons, my lord.
Cross-examination. You had not done cross-examination.
No, no,
How
my
many
lord,
witnesses?
Not allowed. And, my
Not
lord,
allowed.
not allowed.
Where,
And, my
where
lord,
have you stated?
my lord,
Where have you stated not allowed?
my lord, my lord, second property reply, my
Where? You have the records, madam?
It is given, I just said sent someone.
Okay. Okay, let us hear this.
my second reply, my lord, it is a page 43, annexure 19.
Yes.
From paragraph 3 onward, my lord. Page 43. As regards the statement of Bhava Kumar Bora, copy of his statement has been not enclosed with the inquiry. My lord, he did not turn up before the inquiry officer also, my lord. Some statement was, my lord, sent to the inquiry officer. He is the main person, my lord. He lodged the complaint against me, my lord. PW1. That is the Inspector Bhava Kumar Bora. I have stated in para 3 of my lord, second Inspector's reply. The Bhava Kumar Bora copy of the statement has not been enclosed with the inquiry report, so I could not go through the
Okay, state the facts. Okay, let us hear the matter.
statement. My lord,
What do you do?
my lord, I was in charge, my lord, in the, my lord, is the to be
Appointed when? Appointed when?
appointed, my lord, 1992, my lord.
As?
As my lord, ASI.
Then promoted. ASI.
ASI.
Promoted to SI.
To SI.
When were we promoted?
Promoted, my lord, in 2016, my lord.
2016 promoted. Okay, then what? This record was given to you.
My lord, first of all, my lord, can you see page 21, my lord? This is the letter, my lord, whereby lord senior account officer returned the my lord pension file of one Chidananda Bora. Chidananda Bora. It is stated like this, my lord. It is further observed that the service detail incumbent recorded therein for the period 1986 to 2015, 28 years, not verified and signed by DDO. So my lord, it is my lord negligence of the department.
No, no, what,
because-
we are not on the merit, on
Yes.
the charges, then what happened?
Then my lord,
We'll come to the merits of the charges later on. Let us see the procedure which was adopted. Where is the show cause notice?
yes, my lord. So page notice, my lord, page my lord 26,
26.
page 26.
Okay. Drawn up. Show cause, no, this is not so cause, this is suspension.
Suspension, my lord, suspension
Suspension.
order, suspension.
Suspension. Suspension is 8-4. 8-4-20 suspension,
First cause, my lord, page 27, next page.
27.
Yes,
Okay, 18 April.
yes, 18 April.
Okay.
There is allegation like this, that while you were posted as APRO headquarter, Ulubari in staff in charge of pension cell, you refused to receive a file which was endorsed to you as directed by SPC headquarter to the left the file on the table of APRO headquarter in the indisciplined manner, showing challenging gesture to RI APRO headquarter in front of the staff. This is the allegation.
Okay. Then what happened? You filed your reply.
Yes, ma'am. I filed a reply. Initially, my lord, I asked for the document, page 29, my lord.
Hmm.
I asked for the document, page 29, dated 20 of April 2020.
Ask for documents, yeah?
Yes,
Okay, then.
document not supplied, my lord. I was asked to inspect the document.
Inspection
Ye-
was, inspection granted.
Inspect, my lord, but inspect, my lord, I could not fully go through, my lord, and prepare the,
Doesn't matter. Then, you start,
my lord, my WS is page 32.
32,
Yes,
4-5.
4-5 minutes.
WS, written statement of defense.
Yes, ma'am.
Yes. Thereafter,
Thereafter, my lord, this,
inquiry officer and presenting
my lord,
officer.
order dated 11 May 2020. Inquiry officer appointed.
Inquiry officer and presenting officer appointed.
Yes, yes.
11/5/2020. Inquiry officer and presenting officer appointed.
My lord.
Okay. Yes.
That my lord, department proceedings commenced, my lord.
Hmm.
In the meantime, my lord, my lord, I was reinstated in service,
11/9,
my lord.
page 38.
Page 3,
11/9/2020, suspension revoked,
suspension, yes,
revoked,
revoked,
reinstated.
reinstated. Thereafter, my lord, this order of punishment dated 14/9/2020. My lord, this order not accompanied by, my lord, statements, my lord, recorded by the inquiry officer. Only, my lord, accompanied by a report, my lord. As many as 7 witnesses examined, my lord, and this statement not accompanied.
Statement is not required to be accompanied. You are entitled for a report.
Because, my lord, I could not, I could not, my lord, examine.
That was
the
that was at the stage of the inquiry. After the inquiry is over,
Yes.
you are entitled for a report.
report.
You
my
may still
lord,
have a case that you are not, the inquiry was not properly held because you are not given these statements for which you could not cross-examine. That is a different aspect, but those statements are not required to be given with the report. It is only the report.
So report, my lord, report is page 40, man.
Okay, let us see 13.
Um,
Yes.
The report of my lord, it indicated the statement discussed, my lord.
Yes.
Finding is at the lastly the finding.
What is your name?
Well, Bharat Chandra Das.
Okay.
My lord, my case in the specific that my lord, I did not do so, my lord. Insubordination is not there. Because I pointed to my lord that the defect to my superior.
Say,
That is
Mr.
the,
Chauhan, we cannot go into that, those aspects. Those are within the factual aspects. We cannot go, but we can certainly go into the procedure. Whether you are given an opportunity of cross-examining.
no, my lord.
Number one, that is one aspect you can highlight. Whether the inquiry was held by following the due process of law. And number three, whether the penalty imposed is after giving an opportunity on the inquiry report, officer's report.
My lord,
Where is your reply here?
my lord, reply page 43, my lord. And my lord, first specific ground that my lord, no opportunity of cross-examination was given to me.
Yes, madam, the cross-examination, was it given?
Lordship, as per the inquiry report, there is a, just take 5-10 minutes time to get the
Okay,
report.
let us have a look at the inquiry report at page 40.
Yes.
That will perhaps throw some light.
There are all statements of the witnesses, Lordship.
Yes.
Then the findings is stated. In the findings, one thing is noted, Lordship, in page 42.
Yes.
One notice is being served to SI at RT Bharat Chandra Das under suspension to present or submit in written, if any, in favor of his defense witnesses, anyone to the undersigned, within 3 days from receipt date of the notice, file number so and so dated 11/6/2020. But it's observed that
Mr. Chauhan,
My lord.
was your client present in the inquiry?
Yes, he was present.
He was present.
Yes.
The witnesses were had come or their statements were taken
My
into
lord, the main
consideration?
witness did not come, my lord. My lord, he sent a recorded
Statement.
statement.
Who did not come?
My lord, issue one, main complainant by Inspector Bhava Kumar Bora.
He was not there.
No, he was not there. Only his written, my lord, statement in the paper, my lord, sent to inquiry officer. Others were there, others were.
if your lordship can be peruse para 15 of the writ petition, lordship, what they have stated.
Just a minute. Para
Paragraph 15, I'll rely,
of the
lordship.
written
No, lordship,
writ petition.
writ petition, page 10.
Yes, please. Yes.
Para 15, they have written, the petitioner states that the presenting officer presented 4 witnesses, listed witnesses, namely so and so. And their statements were recorded, but the petitioner was not allowed to cross-examine any of the witnesses by the inquiry officer. So here, how they can say that this was not recorded? In their statement, they are saying that it was recorded. That means the petitioner was present before the statements were
Petitioner
recorded.
I
said
was
he
present.
he
I
said
was
he was
present.
present.
I was present. I'm not denying.
Where in the petition you have stated that this Bhava Kumar did not even come, his pre-recorded statement was used.
My lord, in my reply, my lord, after
Now
the.
they have come with a
second
new
so-called
fact in
mail.
the reply, lordship. This is there.
Which reply?
Affidavit in reply, lord.
Had there been cross-examination, nothing has been discussed, my lord, in the inquiry report. Nothing, my lord. In respect of 7 witnesses, not in case of any witnesses it is discussed.
Where
That-
in the reply affidavit,
My lord, reply page 43, my.
which paragraph?
Paragraph 3, my lord. As regard the statement of Bhakumar Bora, copy of his statement has not been included in the inquiry report, so I could not go through his statement. I was not given chance of inquiry officer to.
Paragraph
cross-
3.
Three, my.
Paragraph 3 it starts as regards the statements made in 5.
Statement, yes.
It starts with what? That it regards the statements made in 5 of the FNN opposition.
My lord, it is a reply to second so-called, my.
Oh, not the reply affidavit.
No,
Then reply to second show cause is a part of the proceedings. You can have it.
lordship.
Page.
Page, my lord, 43. Dated, my lord, 23/9.
No, where have you stated in the pleadings of this petition that this witness Bhava Kumar Bora never came for his cross-examination? Have you stated anywhere? No.
My lord, his statement, I stated his statement, but then his statement was.
No, we are examining a very fine aspect. You are saying that one of the witness never turned up. His pre-recorded statement has been used.
My-
This statement of yours, where does it find in the pleadings? Have you stated anywhere that Bhava Kumar Das has never come to the proceedings? Madam, your records will be,
Yes, sir. There,
But-
it should be.
but I think you need a very serious kind of a refreshing course for your officers. You don't know how to conduct a proceeding.
Lordship.
Mr. Chauhan has not argued. There are many aspects which If in today, after in 2021, 1920, you are making such
Sometimes,
mistakes.
yes, Lordship, sometimes it is found and
No, there is a standard procedure. There has to be an SOP. How do you go ahead with the proceedings? This is not how you go ahead with the proceedings, irrespective of what is argued or not argued. Matter is before us. See how the inquiry report has been written. This is not how you write an inquiry report. See what is the second so-called notice stated.
yes,
What are the case laws? Any case law?
My lord, yes.
Which one? Name.
My lord, one my lord, Union of India, S.K. Kapoor, another from our High Court, my lord, Union of India, and Dharmeshwar Payang.
On what aspect?
My lord, my lord, document not supplied.
Documents are given here. There's only one document. There are direct case laws. These are on documents. Your
Document,
case
my lord, I was allowed to inspect only, document not supplied.
not required. Inspection is good enough. That is not a point. You have other points available with you.
My lord, the non-cross examination, my lord, is a direct violation of Article
So
300.
show us some decision.
On that point, I have not
So
come.
what is that point you are trying to make?
My lord,
These are not the points which will help
my
you.
lord, my lord, it is the cross examination, non-cross examination allowed, my lord, not
If you
allowed,
think
my
that
lord.
that is a
And my
substantial,
lord, that is the violation of
if
my
you
lord.
think that that is a substantial point in your favor, you should have got a case law. We also think that it's a point which is in your favor. There are other points. You have not taken up those points.
My lord, a violation of natural justice, my lord. Because
Simply saying violation of natural justice will not do. How do you relate that submission of yours of violation of natural justice? What is the requirement? Yes, madam, you have the records.
yes, Lord.
Yes, let us see the inquiry proceedings. So, Chauhan, if you do not assist the court, how
My
can
lord,
we help you?
my lord, in the report, my lord, there is no discussion at all, my lord, about the cross-examination. Had there been cross-examination, some
That
sort
you
of
have already
discussion-
made, that there is no cross-examination. You need not elaborate on that. Now show us some law.
My lord, I have not come with that.
Yes, so let us have a look at the inquiry report. You have not formulated any grounds on the second show cause the notice.
Second so-called, my lord, I have taken a specific ground.
What ground?
I was not allowed to cross-examine my.
We are on the aspect of the second show cause notice itself, legality of that. We are not on the ground of cross-examination. You have already stated that notice is faulty. You have not even seen the notice. We are sorry to say, no assistance. Where is MD Karunakar? MD ECIL, Karunakar case. Where is Ramjan Khan case? What is the requirement?
Requirement procedure, my lord.
What is the requirement? Tell us. Only the inquiry proceeding, madam, nothing
Yes,
else. Is it there or not?
it's there, but all but yes, sir. With me. But there is also another thing, when he was asked to give his defense witnesses, lordship, he did not respond to that. This is also their lordship.
No, first you have to overcome your burden. First, have you discharged your burden of proving the charges in the manner prescribed by law? He may not give his defense witness, not necessary. There is one statement by the inquiry officer, Mr. Chauhan. In the course of the inquiry, statement of 5 prosecuting witnesses were recorded in presence of the delinquent, so-and-so, read out, and he admitted as correct and signed there in the statements of prosecuting witnesses accordingly. He was given opportunities for cross-examining the prosecution witnesses. Your grounds which you are trying to formulate are not available to you, and neither those are factually correct. You see the statement of Inspector Bhaba Kumar Bora, his statements, then you are asked questions. You have signed on every page. You see?
Hey, for my lord, you are present here.
No, your instructions may not be correct. You have to have a look. That is why we see the records. See the handwritten portion on all those. On below your signature read over and accepted to be correct. On the foot, that is you. Second page, see
Yes.
the question has been put to you. Do you agree? You say yes, I agree.
Yes, my lord, his signature is there.
And that person was there, that inspector, what is his name? Baba.
Yes.
He was there. You said he was never there.
Number one with
Yes.
Signatures are there.
You still have a case, Mr. Chauhan. Even if we come to a finding that the inquiry was properly held, even at the stage of second inquiry, second show cause, you have a case. You have not been, neither you have argued nor you have structured your petition. You look at the second show cause notice. Case 39.
Page, second stoppage, my lord,
Page 39.
page 43.
39, not 43. 39, the notice.
39, my lord, is the order of the superintendent of police.
That is the
commission.
second show cause notice we are saying.
Yes.
This is not the second show cause notice.
Yes, notice.
You read this, what is wrong with this? Okay, it's not not with cumulative effect.
suspension period also has been treated on duty, lord.
No, no, no. My lord, certain another order is also there, page 46.
46.
Yes.
Yes. Enforcement period. This period not on duty.
Yes.
Not on duty. Suspension was for how many months? 5 months.
Yes, my lord,
Eight-
from
eight-
8/4/2020 to 10/9/2020.
It's 38. Okay. लिखा। An order of penalty. dated 25/9/2020 of withholding of one increment without cumulative effect and a subsequent order of 30/9/2020 of holding the period of suspension of the petitioner in service from 8/4/2020 to 10/9/2020 to be not on duty are the subject matters of challenge in this petition instituted under Article 226 of the Constitution of India. Full stop para. Bereft of the details, comma, the necessary facts, comma, as projected are that the petitioner who was appointed as Assistant Sub-Inspector of Police in the year 1992 was promoted to the rank of Sub-Inspector in the year 2016. Full stop. 16 and was posted in the APRO headquarters. Full stop. On an incident relating to return of the file of an incumbent as communicated by the senior accounts officer, comma, a disciplinary proceeding was initiated against the petitioner, in course of which he was placed under suspension, filed and order dated 8/4/2020. Full stop. The same was followed by a so-cause notice dated 18/4/2020, along with in which 4 numbers of witnesses were cited, along with documents. Full stop. Though the petitioner had asked for copies of the documents, comma, it is alleged that such copies were not furnished, comma, however, comma, inspection of the same was granted. Full stop. Accordingly, comma, the petitioner had submitted his written statement of defense on 4/5/2020. Full stop. Not being satisfied with the reply of the petitioner, comma, an inquiry was constituted and wide order dated 11/5/2020, comma, inquiry officer and presenting officer were appointed. Full stop. In the meantime, comma, wide and order dated 11/9/2020, comma, the suspension was revoked and the petitioner was reinstated in service. Full stop. And on completion of the inquiry and submission of the inquiry report, comma, the petitioner was issued a second so-called notice on 14/9/2020, enclosing therewith a copy of the inquiry report dated 18/6/2020. Full stop. The petitioner had accordingly submitted his reply to the second show cause notice. Full stop. However, comma, it is the case of the petitioner that without taking into consideration the response of the petitioner in its proper perspective, comma, the impugned order of penalty was passed on 25/9/2020 and as indicated above, comma, wide the subsequent order dated 30/9/2020, comma, the petitioner was treated to be not on duty from the period of suspension, for the period of suspension from 8/4/2020 to TO2 10/9/2020. Full stop. Para. Sri Chauhan, I have heard Sri S. Chauhan, learned counsel for the petitioner. Full stop. I have also heard Miss M. Bhattacharya, learned additional senior government advocate Assam, who has also produced the original records of the departmental proceedings. Full stop. Para. Sri Chauhan, the learned counsel for the petitioner, has submitted that there was no basis to formulate the charge as there was no misconduct of any insubordination which could have been attributed on the petitioner. Full stop. By referring to the communication dated 18/10/2019 of the senior accounts officer, comma, the learned counsel has submitted that for such a trivial matter, comma, the charge of insubordination could not have been leveled. Full stop. Para. As regards the challenge on the procedure adopted in the inquiry, comma, the learned counsel has submitted that in the inquiry, comma, the petitioner was not given any opportunity to cross-examine the witnesses. Full stop. In this connection, comma, the learned counsel has referred to the reply filed to the second show cause notice, wherein the aspect of not allowing him to cross-examine the witness was highlighted. Full stop. It is submitted that the petitioner was deprived of a fair opportunity in the inquiry, which resulted in a finding against him. Full stop. It is also submitted that the prime witness, Bhaba Kumar Bora, did not turn up in the inquiry proceedings, and only his pre-recorded statement was utilized without giving any opportunity to the petitioner for cross-examining the said witness. Full stop. Para. Sri Chauhan, the learned counsel, has relied upon the following two decisions in support of his contention. Number one, 2011 4 SCC 589 नाम लिखिबा. Number 2, 2018 1 GLT 147. Full stop. Para. In the case of S.K. Kapoor, comma, the Honorable Supreme Court has laid down the requirement of making available all materials to a delinquent in an inquiry, in absence of which, comma, there would be violation of the principles of natural justice. Full stop. The said view was also taken aid of by this court in the case of Dharmeshwar Payeng Supra. Para. Par contra, comma, Ms. Bhattacharjee, Learned State Council, has submitted that the role to be played by a writ court in matters of examining a disciplinary proceeding and its outcome can only extend to the aspect of an examination as to whether a fair procedure was adopted and the decision-making process was lawful. Full stop. By refuting the allegations that the petitioner was not afforded a chance of cross-examination, comma, the Learned State Council has submitted that the records of the proceeding would reveal otherwise. Full stop. By placing the said records before this court, comma, the Learned State Council has submitted that the same would reveal that not only the petitioner, not only the statements were recorded of the witnesses who were present, comma, the petitioner was given a scope of cross-examination, and in fact, questions were also put to him based on the said statements. Full stop. Para. This court has carefully looked into the records, including the proceedings of the inquiry, which reveals that the petitioner was present, which reveals that the statements were recorded, statements of the witnesses were recorded in presence of the petitioner, whose signature appears on each page of such proceeding. Full stop. To ensure fairness, comma, the original records were also shown to Sri Chauhan, the Learned Counsel for the petitioner, for his satisfaction. Full stop. Para. This court has come to a finding that the procedure adopted by the inquiry officer while conducting the inquiry appears to be a fair procedure wherein reasonable opportunity of defense was granted to the petitioner and fairness was maintained. Fairness and transparency were maintained. Full stop. Para. This court is accordingly of the view that the enquiry and its findings cannot be found fault with, full stop. Para. Having held that comma, this court has also looked into the nature of the allegation, which is of insubordination in connection with not forwarding a file of an incumbent, full stop. Taking the same into consideration, comma, while this court is of the opinion that no case for interference is made out so far as the order of imposition of penalty dated (25/9/2020) is concerned, comma, the subsequent order dated 30/9/2020, whereby the petitioner has been held to be not on duty for the period from 8/4/2020 to 10/9/2020 is required to be interfered with, full stop. It is accordingly directed that the suspension period from so and so, 8/9, be treated to be on duty, and accordingly the balance amount of his salaries which would be admissible to him by deducting the subsistence allowance already paid be released to the petitioner, full stop. The said release be made within a period of 4 months from the date of receipt of a certified copy of the order, full stop. Writ petition accordingly stands disposed of in the manner indicated above, full stop. The original records are handed back to the learned State Council.
Tip top.
Economy. Mr. Bhattacharya, what is
Yes,
this?
madam, I am for the respondent. I filed my affidavit, my lord.
None appears for the petitioner on call, whereas Sri P.S. Bhattacharya, learned CGC, is present, who further submits that affidavit in opposition has been filed, full stop para. In the interest of justice, matter is adjourned by 2 weeks.
Obliged.
What is the issue? What is the issue?
No, no, regarding dismissal of garbage disaster, madam. Disaster.
Deserter
Yes.
from force,
Unauthorized leave, my
from
lord.
force.
CRPF.
Here,
Supreme Court.
okay,
Overstay, my lord.
okay.
Make result. My lord, in this case, government is supposed to file, PNRD is supposed to file their affidavit.
PNRD, Madam Bormon, who is appearing for PNRD? PNRD, there are standing counsel. S. Dutta, then Mr. Hendik.
He was there. Just 3 minutes there.
They have not filed.
Not filed, lord, but the affidavit is very much.
Sri K. A. Mazumdar, learned counsel for the petitioners, has submitted that response is yet to be filed by the contesting department. Full stop. Yes, where is your response?
But I've received some instruction from the department.
Sri P. Hendik, learned standing counsel. PNRD department submits that some instructions have been received. You file your affidavit, or can we dispose if on the basis of these instructions?
My lord can dispose.
What is the matter?
Lordship, regarding consideration of seniority, Lordship, from the date of original appointment. Actually, what has happened in this case, petitioners are the tax collector. They are working since 1996, but their service was regularized in the year 2013.
Hmm.
But a gradation list was prepared. In the state gradation list, Lordship, no date of appointment, no, nothing is there, Lord.
Okay.
So let affidavit should be
Now,
filed.
what is your instruction?
My lord, my instruction says that in the year 96, they were appointed as ad hoc. appointments. He hosts the recruitment. They were appointed, he hosts the recruitment. Subsequently, my lord, the state granted them concession by regularizing their services with effect from 1st of June 2013. So 2013 is the date, Lord, when they are considered as have been entered into the services of the state. So from 2013 onwards, my lord, their qualifying service will be counted. Accordingly, my lord, Supreme Court judgments are clear that once ad hoc employees are regularized, the purpose of seniority is concerned, period service served as ad hoc period is not counted. And they have already got a concession by getting regularized. Now they're saying that they should be regularized from the date of initial appointment. That is not possible since their
Lordship,
recruitment was
Let
only
him,
not.
let my learned friend file his affidavit, Lordship. I shall try to satisfy your Lordship on that point. And apart from that, in PNRD department, Lordship, they are the provincialized employee. From the date of original
Okay,
and others were
has
also not.
received? You legal? Received. For the fee accordingly, prays for and is granted 3 weeks time to file affidavit in a place.
Lordship, he may file affidavit, Lordship. I will try to satisfy your
Yes.
Lordship.
File your affidavit, let him have a opportunity.
Much obliged, Lordship. 9 is also same, Lordship.
8 and 9.
Much obliged, Lordship.
Yes.
Another matter relates to the completion appointment. They have filed the reply. We have also given a reply.
Yes.
Now, the only question is that there is a judgment of our own High Court matter. That is in page 1918 matter. But you will put that. Similarly situated case.
You will be representing the department.
I'm contacting Mr. Holder because this thing, PWD, there's something about PWD lawsuit in the matter. They have
Okay.
also filed their affidavit.
Where is Mr. Dhar?
Yes, I'm contacting over
Okay.
telephone.
When was the death? When was the death?
And that death was married in 2007, madam.
2006.
6 married. And she applied on 2007, madam, on 447. Now their stand is that since at the time of death, his service was not regularized, he will not get. But to that extent, there is a judgment I have annexed of our own High Court, my lord. In similar situated cases,
Death, when was death? 31/12.
yes,
What was the name?
her husband's name is,
Okay, what did he do?
he was a Group D employee, my lord.
Huh?
PW Group D employee.
Grade 4.
Yes.
Mr. Dhar, we go, this compassionate appointment.
My lord.
We are hearing this matter?
My lord is taking up.
Yes, yes.
Right.
He was a grade 4 employee.
Yes, sir.
Husband of the petitioner.
Yes.
In PWD.
Yes.
Where was he posted? Which place?
My lord at Teshpur, my lord.
Teshpur. Died 31/12.
Yes.
2006.
Yes.
Okay. He applied on 2007.
Yes.
Yes.
My lord, there is a series of correspondence, my lord. Now their stand is that since his service was not regularized,
Okay.
so we cannot consider her case.
Where do you get that stand?
My lord, but there is a judgment of our own High
Now,
Court.
where
which
is
I-
that stand?
Beg your pardon.
Where is that stand? From where is the stand discernible? That on the ground of non-regularization of the
No, they have
service?
sent a reply to me, my
Where?
my lord. Because I wrote a letter to the Prime Minister, my lord.
Hmm.
Page 8, my lord, your lordship will get. Page 38, my lord. My lord, to that, my lord, there was an order to give reply of me,
Page
page 38, my lord.
38.
38.
Yes,
Then, my lord, they have given reply in 39.
yes.
With reference to the subject cited above, I regret to inform you that your candidature for appointment on compassionate ground could not be considered as your husband, late Ranjan Kumar Das, was a work charge section assistant under Office of the Executive Engineer, PWD, Punitpur Rural Road Division. Family members of the regular and members of only regular employees are eligible for the appointment on the compassionate ground.
Yes.
Now, there is a judgment of our own High Court, madam. In a similarly situated case, my Lord Honorable High Court has directed to consider the case of the petitioner. Earlier also she came before the Honorable High Court, my Lord. Page 16, you will get.
16.
16, my Lord.
Yes.
My Lord, the relevant portion is that, my Lord, of the judgment is that your Lordship will find in page page 18. In her reply, affidavit petitioner has stated that one Hiru Soikia was serving as work charge section assistant in the office of the respondent number 4. He also died in harness on 21/7/66. His brother, Sri Deepak Soikia, had filed an application seeking appointment on compassionate ground. Along with the petitioner application of the said, Sri Deepak Soikia was returned back by the office of the respondent number 2 to the respondent number 4 on the ground that both the cases do not fall within the purview of the compassionate appointment. Therefore, Srimati Anju Soikia, wife of late Hiru Soikia, filed a written writ petition before this court in the registered number such and such. This court, by order dated such and such, disposed the said writ petition by giving liberty to this thing, Srimati Anju Soikia, to approach the departmental authorities by filing application to consider her case for appointment on compassionate ground. This court observed that in the event of such application was made, the respondent may consider the same as per the guidelines laid down in the Achyut Ranjan Das versus State of Assam, reported such and such. Thereafter, by communication dated 23/10.
Okay, that's we have read.
Yes.
That there is no distinction between a work charge employee and a
yes.
regular employee so far as consideration for compassionate appointment.
The
is-
judgment has said that it because Anju Soikia got the appointment on the similar situated cases. And against the judgment, the state government has not preferred an appeal also.
Okay. Thereafter,
Thereafter, till today, they are not considering.
but from 14, what did you do?
But I am just doing some tuition, etc.
No, we are not on that. From 14 to, why did you wait till 7 years to approach this court?
Because earlier I made several correspondence. They are said, your lordship will find correspondence from 34 onwards, my lord. One after another correspondence your lordship will find. And lastly, after the receipt of the prime, we approached the lady approached the Prime Minister in letter and directed the government of Assam to give a reply to this her prayer, my lord. Accordingly, I was informed. That is 2019, my lord. Your lordship will find. Page 39. Thereafter, I have again approached to your lordship.
7, 2019.
Page 38 is the letter addressed to the Chief Secretary, Government of Assam, by the Prime Minister Office, my lord.
Yes, Mr. Lord.
My lord, we have filed an affidavit filed by respondent number 3, my lord. Filed by respondent number 3, one Mustaq Rahman, my lord, Deputy Secretary,
to the government of PWD road. And here by default that page, running page is not just for
Space 40.
page. So my lord will go to para 4 of our affidavit, man. Because as per the Honorable High Court order dated such and such on 14, whereby the Honorable High Court has directed
Para?
to para 4, man.
Para
The next
4.
page, sir.
Okay. Oh.
The period of 4 months. As per the order of the first phase for the SLC in 2018. Again, my lord, in 2018 we have considered. So now, my lord, this consideration part, it comes in 2 legs, my lord. First is, it was rejected by the SLC on the ground that 5% quota already filled up. First ground. And second ground, my lord, more than 11 years have left since the death of husband. That is the Ajit Ranjan Das, my lord, 2 years. And now, my lord, Debarwal Tiwari, 2006 and 2024.
But don't you think that the your contention that the matter of the petitioner was placed before the SLC in June 2018, and you had cited 2 reasons. One is there is no 5% quota. Number 2, 11 years have elapsed. Now the period has also increased. That's a different aspect of the matter.
Right.
But in your reply
Right.
on 6/7/2019, which is subsequent to your SLC minutes,
My lord.
you state at page 39 that the husband's job was on a work charge basis, so he'll not come within the purview of this scheme.
See, my lord.
If there was a actual consideration by the SLC
My lord.
on the grounds of lack of vacancy as well as delay, you should have informed these reasons. These were existing reasons of 2018.
My lord.
You had cited a different reason.
My lord, that SLC has already done, my lord. This is from the department, man.
And the
This SLC has already considered, my
And
lord,
that
committee, man.
reply was by whom? 6/7/19 was by whom?
6/7/19 is from my lord, PWD department, man. Bro.
Hey, Deputy Secretary, my lord.
It is from the department, my lord. Whereas SLC is the chief secretary in the committee, my lord. They have, in their own wisdom, my lord, they have considered it.
No, this affidavit is also by the department.
Department, my lord. But department is returning, my lord, the decision of the SLC, my lord. What SLC has taken, my lord.
You have got the SLC. Has it been?
That my lord is not here, my lord. But this is on affidavit, my lord. They have said it.
See, delay aspect as laid in Tiwari case, that would be relevant, but that is can you wholly ignore the other aspect? At least you should, your stance should have been consistent. Whatever you stated in your reply.
My lord, already 2018 is rejected.
That is that rejection. The grounds of rejection should have been intimated. You say something else.
Yes, my lord. My lord.
And had it been that this communication to the petitioner was of an earlier date, you do not know what is the, you say that no, his work charge, but SLC actually considered and rejected for some other ground. That would have been a different aspect altogether. Here, there was an existing decision of the SLC which was required to be communicated, which you did not. And on the other hand, you submit a reply after the PM letter on 6/7/2019, citing a totally different ground, which ground was also taken care of by this court in an earlier proceeding.
Yes, my lord. My lord, that is there, but that SLC rejection still stands, my lord. If now petitioner wants something, he has to challenge this SLC. It's rejected, my lord. It has been considered and rejected, my lord, on 2 grounds.
Okay, hard facts, but okay. The issue raised in this petition is towards a claim for appointment on compassionate ground. Full stop. The facts projected in this petition by the in this petition is that the husband of the petitioner, late Ranjan Kumar Das, please have your seat, Mr. Ranjan Kumar Das, was working as a grade 4 employee in the Public Works Department at Tejpur, who had died in harness on 31/12/2006. Full stop. The petitioner, who claims to be eligible and qualified, had accordingly applied for appointment on compassionate ground on 4/4/2007. Full stop. As the said application was not duly considered, comma, the petitioner had earlier approached this court by filing WPC 7473 of 2013, full stop. In the said case, comma, the apprehension of the petitioner was revealed that the lack of consideration might have been on the stand, might have been on the basis, might have been on the ground that the husband was working on work charge basis and not a regular employee, full stop. The said writ petition was disposed of by this court wide order dated 28/3/2014, wherein it has been held that for the purposes of consideration for appointment on compassionate ground, comma, no distinction should be carved out between a regular employee and a work charge employee, as such employee also gets the GPF and other benefits. Full stop. In spite of the said judgment, comma, no action was taken, and accordingly, the present writ petition has been instituted. Full stop. Para. The learned I have heard Sri S.C. Biswas, learned counsel for the petitioner, whereas the Public Works Department is represented by Sri R. Dhar, the learned standing counsel. Full stop. Para. Sri Biswas, the learned counsel for the petitioner, has submitted that on persistent approach by the petitioner, comma, a communication was issued to her on 6/7/2019, whereby the ground of rejection was stated that the deceased government servant was on work charge basis. Full stop. It is submitted that the aforesaid ground was already taken care of by this court while disposing of the earlier WPC 7473 of 2013 wide judgment and order dated 28/3/2014. Full stop. He accordingly submits that necessary directions be issued for a fair consideration and appointment of the petitioner on compassionate ground. Full stop. Para. Per contra, comma, Sri Dhar, the learned standing counsel of the department, by referring to the affidavit in opposition filed on 10/1/2022, has submitted that the case of the petitioner was indeed considered by the state level committee on 19/6/2018. Full stop. Upon such consideration, comma, the case of the petitioner was rejected on the grounds of lack of vacancy as well as a lack of vacancy within the 5% quota, as well as the delay in such consideration. Full stop. The Learned Standing Council submits. In this connection, comma, the averments made in paragraph 4 of the affidavit in opposition dated 10/1/2022 have been pressed into service. Para. The Learned Standing Council further submits that the writ petition has been filed only in the year 2021 and the death of the government servant was in the year 2006. Full stop. Therefore, any direction for consideration of the case of the petitioner at this stage would not be in consonance with the objective of the scheme. Full stop. The Sridhar relies upon a recent judgment of the Honorable Supreme Court in the case of Debabrot, State of West Bengal versus Debabrot Tiwari. So and so, huh? Para. The rival contentions have been duly considered and the materials placed before, right? Para. The stand taken by the respondents in the affidavit filed on 10/1/2022 is that the consideration consideration of the petitioner by the SLC was indeed done on 19/6/2018 and on the grounds of lack of vacancies within the 5% quota and the period which has elapsed in the meantime were taken on the grounds of কি করলো in the meantime considered by the the candidature was rejected. Full stop. Though apparently the said grounds which have been placed on record by way of affidavit does not appear to be consistent with the reply dated 6/7/2019, comma, the aspect of the long intervening period of about 2 decades from the date of death cannot be ignored or overlooked. Full stop. The petitioner, the first writ petition was disposed of in March 2014 and the present writ petition itself has been filed on on
8/4/21.
the date somewhere. in the date somewhere. On 8/4, is it? On 8/4/2021, 8/4/2021. Full stop. Para. The Honorable Supreme Court in the aforesaid case of Devabrat Tiwari has laid down as follows. Full stop. Para. The objective of the scheme of compassionate appointment, which is an exception to the general rules of recruitment, is to give immediate succor to a bereaved family which has lost its sole breadwinner, and the same cannot be a matter of right, full stop. In any case, comma, the entire objective would lose its essence in case of elapse of a considerable period of time. Full stop. In the aforesaid case, comma, the Honorable Supreme Court, as indicated above, had gone to the extent that even if the delay is on account of the respondent authorities, comma, that would also be considered for that would also be taken into account while considering the case for appointment on compassionate ground. Full stop. In the instant case, comma, the delay, the period from 2006 is a considerable period, and therefore any further direction for consideration of the case for appointment on compassionate ground of the petitioner would not be in sync with the scheme of compassionate appointment. Full stop. Para. Accordingly, this court is of the opinion that no relief can be granted to the petitioner in this case, and accordingly, the petition is dismissed.
Already, with all
Third
respect,
case,
in
sorry.
that case, there was no scheme of this Ranaghat Municipal Board.
Where?
This case that you have lastly referred. There was no scheme.
You see the paragraphs. Paragraphs are very hard.
Well, that I have read, my lord. My
Even
pen
for
has
delay
given
on
me.
the part of the authority.
But there was no scheme of the
It's
board.
not on a particular scheme. It is on the scheme general of compassionate appointment. Everything has been discussed.
14. My lord, petitioner was appointed temporarily as a sweeper in the appointments tribunal at Morigaon as a temporary basis, my lord, since 2009. Thereafter, her salary was.
Who is
during that
appearing,
time-
madam? You are appearing.
Yes.
You are appearing.
On person number 2.
Who is two?
Number
Who is
2, member
Ernest
of
Tribunal?
foreign people.
Member. Who has taken the decision? You have taken the decision. You have taken it's your decision which has been challenged. File affidavit. Okay. What is the impugned decision?
So, my lord, admittedly, petitioner has been rendering her service for 11 years, my lord,
As sweeper.
as sweeper, my lord, and without any blemish, my lord.
Mm.
And now she is replaced by the respondent number 3 as same category, my lord, as a temporary basis. They have admitted, and only ground is that she was cautioned and she was not followed. That's why she was released.
She
That is-
was cautioned. You did not perform well or what?
My lord, actually, it is not on record. They are in their affidavit. They have submitted in affidavit para 5 that the writ petition was verbally warned several times, but as the writ petitioner did not pay any heed to the warning, apprehending that such activities may spoil the environment and may and bring disrepute to the tribunal, the writ petitioner had to be released from the engagement as required. Therefore, thereafter, as the respondent number 5, who was willing to do the cleaning work in the tribunal, he was being engaged on daily wage basis subject to availability. Now, the principle is that, my lord, a daily wage labor, this is the
Service is related.
temporary employee cannot be replaced by another temporary employee.
Is the service upon the respondent number 3 complete?
My lord, yes. As per the office note, my lord, dated 17 to 2023, one Ukalatnama has filed. Yeah.
What, that is for R2. What
No.
about R3?
R3, my lord.
17?
17 to 2023, Ukalatnama is filed as per the office note. I have sent it to them in the middle of the office note. ma'am.
Three or two? Whose name appears?
As per office note, it is 3.
I think it is 2, I think. 3, there is some mistake, it
Maybe, my
seems.
lord.
Let us check. Madam, anyone appearing for 3? Second file too. Just check the Wakalatnama. Huh? No, itu to heavy hoy na. 2 no hobo second. 3 hobo itu. Full legis. Don't you know Wakalatnama is na?
Yes. No, Ukalatnama for respondent number 3.
3. Who the council?
Uday Jyotish Paikal. Enrollment number 79 of.
He's for respondent number 2.
I think she is also appearing for respondent number 3.
Separate
No,
Wakalatnama.
Yes, her name is here.
No, RD separate Wakalatnama.
What is a separate Ukalatnama for respondent number 3? Only.
Madam, you are appearing for 3.
No, Lordship, I am for number.
Or 3. What is your name, madam?
Mrinalini Das, M Das.
M. Das. Where is your Wakalatnama?
I am on behalf of Tuesday,
Of?
on the behalf of Tuesday. He is appearing for respondent number 2.
2. And who is Nomi Soikia?
The mayor, number
No, do you know her? And Soikia?
earlier, now she is not practiced.
Okay. Then Nomi Soikia is not practicing now.
Correct.
I think you need to issue fresh steps. You take fresh steps. And madam,
I'll take instruction.
you take instruction, you inform the incumbent.
Yes.
She is in your office, okay? That her earlier counsel is not appearing and ask her to engage, or otherwise you'll go ahead.
Okay.
Because once some counsel is engaged, if the counsel stops coming, we cannot burden the
Yes.
petitioner to take
Yes.
further steps.
That's it.
My lord,
Oh, you need not take fresh steps. We'll say something else.
my lord, I will take.
No,
fresh
not
step.
required, not required.
Not
We'll direct Miss Madam.
My lord.
Heard 3 DCC Fukan, learned counsel for the petitioner. Full stop. Also heard Miss M. Das,
Yes, sir.
learned counsel, who has appeared for the response number 2. Full stop. Do the names of the learned counsel for the response number 3 is not reflected in the cause list, comma. The records reveal that the said response number 3 had entered appearance through a learned counsel, MS Namidas. Full stop. Nami Soikya ne Das kolu. And Das or Soikya? Soikya, I think. What was the name of the council? Das or Soikya? Madam?
Use this case, it's another.
No. The response number 3. What is my name? Nami Soikya and Soikya, not Das. Full stop. Para. Miss M. Das, learned counsel, has however informed that the said counsel is not in active practice. Full stop. Para. Since the response number 3 is presently working under the response number 2, comma, Miss M. Das, the learned counsel for the response number 2, is directed to inform the said response number 3 regarding the case so as to enable her
Right.
to make representation if so advised. Full stop. Para. List after 2 weeks.
What are the date make?
List, yes, tell us. List on, don't say 2 weeks. List on 17th of May.
My lord.
Yes. 17th is okay, madam?
Hold on, Oblige, ma'am.
May I please, Lord?
Yes.
Lordship, matter pertains to compassionate appointment. Petitioner's father died on 22nd of March 2017. Thereafter, on 1st of
APDCL.
yes,
You have a scheme.
yes,
There was a scheme, his case was considered and rejected.
Okay, but you have a scheme.
This, there is no longer a compassionate
No, at that time,
at that point. But
you have filed affidavit.
Yes. On 2nd August 2006.
5, 8, 9, 9, 20, 20. Your father was in APDCL,
yes, my lord. As senior Sahayak, he was working at
senior Sahayak.
yes, my lord.
When did he pass away?
On 22nd March 2017.
Died. Okay. Then
Thereafter, he made an application. The son made an application.
Petitioner's son.
Petitioner's no, my lord, the petitioner.
petitioner is the son.
Yes,
Hmm.
is the son. So he made an application on 1st of November 2017.
Okay. For
There-
compassionate department.
Yes, my lord, for
Okay.
compassionate department. Therefore, thereafter his application was duly forwarded on 7/12/2017.
Okay.
On 7/8/2020, a call letter was issued for document verification by respondent number 6, my lord.
Yes.
And ultimately on 14th of September 2021, the respondent had issued an impugn order. My lord will get at page 56.
Rejecting.
Not rejecting actually. They have accepted 12 candidates, excluding my name.
So that is you have been rejected. There's nothing about your
Nothing.
rejection.
No,
Page 56.
yes.
Where is that? Your it's 14/9/2021.
My lord,
14/9/2021.
yes, my lord.
How many candidates have been selected?
My lord, 12.
Where do you get?
I'm sorry, my lord, 15 numbers of eligible candidates. My lord will get at page 57.
Yes.
Subsequently, as per recommendation of the selection committee, all the pending applications submitted under scheme of 2014 had been considered for their disposal as a one-time exercise, my lord. As per approval of the board of directors, APDCL, 15 numbers of most eligible applicants, 6 numbers in grade 3 and 9 numbers in grade 4 were considered for appointment against APDCL compassionate appointment scheme, so and so, guide order dated 18/2/2021. So they have selected the most eligible candidates. So how they have selected it, there is no mention here in the impugn order. Therefore, they have filed, the respondent has filed their affidavit stating that they have one annexure. As annexure A, my lord will get at page 8. The relevant portion, my consideration would be at page 10, my lord. Oh, sorry, my lord. Page 11 of their affidavit. But my lord,
Page 11.
page 11.
Yes.
But my lord, this annexure nowhere mention who has issued it and from where they have extracted it.
What is your name?
Sumit Wari, my lord.
Serial 18.
18, my lord.
Yes.
This annexure from where they have extracted it and who has issued it, there is no mention, my lord. My lord will get, I will look that it's a mere paper, my lord, nothing else.
What is the consideration?
The consideration, my lord will get at the,
Please read. The family of the deceased
yes,
receives a monthly family pension
of rupees 27,306, which appears to be sufficient to save the family from starvation. Otherwise, also a casual employee gets a lump sum monthly amount of rupees 30,000 only. It is also found that after death of late Shailendra Wari, the family had received a considerable amount of rupees 19 lakh, which if invested wisely could also generate a substantial monthly income. Hence, having regard to the fact of monthly pension and the regular income, which can be generated from the substantial terminal aggregate amount, it appears that there is sufficient adequate financial resources available in the hands of dependents. Hence, the case does not deserve to be considered for compassionate appointment.
Yes.
My lord, apart from that, whether it is a mere paper or not, if suppose it is considered that it's a legal one, then also, my lord,
Yes.
as per the Bulbul core judgment, my lord, that family pension cannot be a substitute for compassionate appointment, my lord. It is also referred recently in 2023, immediately after the Devabrat case, my lord, Devabrat Tiwari case, wherein one of the honorable judges is the same in passing this order, my lord. Bank of Baroda versus Baljit Singh, my lord. Right. here the question, the issue was considered, but though it was rejected in favor of the appellants, my lord will get the issue at page 4, paragraph 16, my lord.
Page 4, paragraph.
16, my lord. The second question of law, which has been laid down, whether advancement of family pension can be the ground for non-suiting the case of the compassionate employment. This is the issue, my lord. So it was
Paragraph 16.
no, my lord. Yes, my lord. Paragraph 16.
Therefore,
Therefore, it is necessary to consider the scheme which is applicable to the respondent in the instant case. It is not in dispute between the parties that the scheme dated 18/9/1998, which has been issued by the way of a circular, is applicable to the case of the respondent. Under the said scheme, both the educational qualification as well as qualification vis-a-vis the income of the candidate making an application for compassionate appointment have been prescribed, and they are to be considered by the employer. In this context, it would be useful to refer the judgment of the High Court, which has raised two questions of law, which are as follows. Number one, whether the case of the appellant can be considered for compassionate employment vis-a-vis the scheme which was in vogue at the time when the Balbir Singh died or subsequent to that. Number two, whether advancement of family pension can be the ground for non-suiting the case of the compassionate employment. That is the ground here they have
yes,
relied upon.
what is the answer?
The answer is basically, though it is against the petitioner, but in that case, there was a scheme, my lord. The scheme provides for the calculation of the monthly family pension, whether it is, but in here, the FPDCL scheme, there is nothing is there that employment cannot, compassionate employment cannot be granted if he is being given the family pension or not. There is no mention. But in that scheme, there was mention. That's why that was rejected. My lord will get there in the next para itself. If your lordship allow me to read from para 17.
Yes, please.
While answering the second question, the High Court has referred to a judgment of the Rajasthan High Court in Muhammad Farooq Bhatti versus SBBJ so, which has relied upon the judgment of this court in Balbir Kaur to hold that objection with regard to the family income cannot be really considered as an objection to deny compassionate appointment. As far as the first question of law is concerned, the High Court has simply stated that the effective date of consideration of the application for compassionate appointment would be the date on which the respondent's father died. The High Court has stated that 1998 scheme was in force as on the date when the respondent's father died, and therefore the said scheme would be applicable. However, we find that while answering the question of law, the High Court has erred on both counts. Next para, my lord. In this regard, we would like to consider the issue regarding the consideration of the financial position of the respondent vis-a-vis the eligibility to be considered for appointment on compassionate grounds. The relevant clause of the scheme reaches so and so. The clause are dependent of an employee dying in harness can be considered for compassionate appointment provided the family is without means of livelihood and the condition of the family in penurious. Next, my lord, calculation formula for income. The following formula would be followed for arriving at the financial position or income of the family. The total of the following amounts received as terminal benefits will be from the resources, balance of provident fund, gratuity, additional retirement benefits, so and so, so and so. Next, also, my lord will get in the down below Roman para 2 pension, monthly income from savings and other investments. In that case, the Honorable Supreme Court has stated that since there was a scheme and the clause is regarding the family pension and so, but in a PDCL scheme, there is no mention or there is no any clause regarding whether he is eligible or not, if he is being given the provident fund or gratuity or not. That is my humble submission before your lordship. And if your lordships have a look at the FPDCL scheme, I have the FPDCL scheme. 14.
Yes, Mr. Chaudhary.
Who is filed an affidavit in opposition matter. The lecture that my friend here is referring to is nothing but an extract of the minutes before the selection committee. If needed, I can produce the original reports of. Now, what is relevant here, my lord, this annexure, this table here, my lord, refers to 15 candidates and their interested financial positioning vis-a-vis the petitioner. Now, my lord, if my lord kindly has page 8. running
Of
page
your
68.
affidavit.
Yes, sir. Page 68, running page.
68.
Yes, it could be. The annexure A of it. Page 8 of it.
The first page.
The first page.
Yes.
Now, the first elected candidate, her name is Mrs. So Archana Deka, remarked fellow with C. Upon examination of the financial condition this case, it appears that after death of so the family had received a sum of 75,813. Now, the selected candidate thereafter, my lords, the figure herein is 1,08,287. The third candidate, my lords, the figure in question is 1,92,231.
Hmm.
The fourth candidate, the amount is 4,40,220.
Hmm.
The fifth candidate, my lord, the amount that was received is 3,60,080 rupees.
Hmm.
The sixth candidate thereafter, my lord, the amount received is 4,87,540. Seventh candidate, my lord, 1,50,196. The eighth candidate, my lord, all these candidates, my lord, have received amounts do not even compare to what the petition. So they have taken the interstate financial positioning of the parties or the applicants concerned, that has been taken into account. Now there, and my lord will observe that none of them are getting the pension of those very persons, my lord. If my lord sees the remark, apart from the petitioner herein, nobody is getting pension.
Okay.
That has been taken into account, my lord, the positioning and the financial condition, which is the mandate as prescribed under Umesh Nagpal. That is the relevant consideration. That has been taken into account, my lord, and the people have been selected on that basis. And the order, the impugn order, my lords kindly had, it's part of the affidavit as well as the petition, my lord. Page 12 of our affidavit is the impugn order.
Yes.
Now, second para from the bottom, page 12. Moreover, as per relevant judgments of the Honorable Supreme Court, as well as the compassionate appointment scheme of 2014, it becomes explicit that compassionate appointment cannot be made ignoring financial resources available to the dependent. Appointments in public service should be strictly on merit, and compassionate appointment is an exception to this. There is no vested right for compassionate appointment. Based on the PDCL compassionate appointment scheme of 2014, 14 numbers in grade 3 and 2 numbers in grade 4 of dependent family members of the deceased employees who died due to accident, mishap, / extremist violence on duty were already appointed in the year 2017 and 18. Subsequently, as per the recommendation of the selection committee, all the pending applications submitted under scheme of 2014 had been considered for their disposal as a one-time exercise. And as per the approval of the board of directors, 50 numbers of the most eligible applicants, 60 numbers in the grade 3 category and 9 in the grade 4 category were considered for appointment against APTCL compassionate appointment 2014 by order dated 20. Besides, APTCL has now notified a new scheme for compassionate family pension in lieu of the compassion. Now, financial condition of the people have been ascertained. That is the basis. And these people who've been appointed, my lords, if the order is to be interfered with in any manner, then rights have accrued in their favor. They are not even made parties with them.
Okay.
They have not filed an affidavit in reply, but we filed the affidavit in August of 2020. They have not filed it.
Yes, anything? else?
My lord. My lord, if your lordships again have a look at page in their annexure B, the impugn order itself, the scheme was effective from 18 to 2014 to 31/3/2017, means for 3 years duration. They have considered this 3 years, all the applications during the 3 years in the year 2021, whether it is logical, that is basically it is illegal, my lord.
No, that you are also considered that submission.
Why? Why, my lord?
That
In,
submission you will not be available to you.
because in their scheme,
If
my
the
lord,
consideration was for others and you are left out, matter would have been different. You are not left out.
I have been left out, my lord.
No, you are considered.
Yes, my lord.
Rejected.
But that
Considered.
consideration is illegal, my lord.
No, that submission you have made,
Yes, my lord.
that the factors which have been taken into consideration while rejecting are not valid consideration.
Yes.
That you have made already.
My lord.
But clubbing the thing in which you are also considered, that perhaps will not be available to you. When was the scheme for?
From
It was. So,
13 to 17.
18 to 2014 to 31/3/2017, my lord.
31?
3/2017.
See, otherwise you just got in. You would not have been within the purview. It is not a case that your case was pending for a long time. Your right accrue for consideration only on 22/3/17.
Yes, my lord.
So that second submission is otherwise also not available. Will go
But my
against-
lord, during that duration, my father's died, my lord.
Your father died when? In 17.
2nd of March 2017.
22/3/17.
it
And
will-
this scheme, they have considered matters which are pending since 14.
2021.
So by length of time, they get a prior consideration.
My
Okay.
lord, in that count. And regarding the payment, already I have submitted.
Oh. The issue raised in this writ petition is towards the claim for appointment on compassionate ground. Full stop. It is the case of the petitioner that his father, Soilendra Wari, was, what was he doing? Permanent employee? What was his
Yes,
post?
permanent employment.
What post?
As senior Sahayak.
Was a senior Sahayak in the APDCL, who, however, had died in harness on 22/3/2017. Full stop. The petitioner had accordingly submitted an application on 1/11/2017 for appointment on compassionate ground. Full stop. The application was duly forwarded on 7/12/2017 and as a part of an exercise for such consideration, a call letter was issued to the petitioner on 7/8/2020 for document verification towards such consideration. Full stop para. However, vide the impugned communication dated 14/9/2021, while 14 numbers of candidates were stated to be selected, 15
15 numbers.
numbers of candidates were stated to have been selected as an one-time exercise, comma, the petitioner was not selected. Full stop. Para. 3. B.M. Decca, learned counsel for the petitioner, while assailing the aforesaid communication dated 14/9/2021, has submitted that the mode of selection of the consideration has not been disclosed.
Yeah.
Full stop. The reasons, however, are discernible or could be learned after filing of the affidavit in opposition by the respondent company, wherein certain documents have been enclosed. Full stop. The learned counsel submits that though certain papers have been annexed, comma, there is no authentication of the said papers, wherein the reasons for not granting the benefit of compassionate appointment to the petitioner have been cited. Full stop. In the para, the learned counsel submits that even if the said document is considered to be valid, comma, the consideration of the petitioner, which would appear against serial number 18, would reveal that the rejection is mainly on the ground of payment of family pension and other benefits on the death of the father of the petitioner. Full stop. It is submitted that such benefits would be irrelevant for the purpose of consideration of compassionate appointment. Full stop. In this regard, comma, the learned counsel has referred to the case of the Honorable Supreme Court in Bank of Baroda versus Baljeet Singh, which has been decided on 21/6/2023. Full stop. In the said case, comma, the Honorable Supreme Court has also made a mention about the earlier case of Baljeet Kaur,
Balbir Kaur.
Balbir Kaur, wherein it has been clarified that the aforesaid two aspects are distinct and payment of family pension should not come into the way while considering a case for compassionate appointment. Full stop. Para. The Sri B. Chaudhary, learned counsel representing the APDCL and the official respondents, has, on the other hand, submitted that there is no indefeasible right of an incumbent to claim appointment on compassionate ground, and such right is only for a fair consideration. Full stop. By refuting the allegations that the documents annexed to the affidavit in opposition filed on 2/8/2022 are not authenticated, comma, the learned counsel for the company has submitted that the said documents are compilation of the minutes of the meeting held on 14/9, is it 14/9? 14/9/2021, full stop. The Sri Chaudhary, the learned counsel, further submits that a close perusal of the considerations of the candidates would show that an inter se comparison of the financial strength, of the financial position of the respective families were taken, which is a relevant consideration. More so when the objective of the scheme is to enable a bereaved family which has lost the sole breadwinner to overcome the immediate crisis. Full stop. Para. The learned standing council has also submitted that a perusal of the consideration would show that the petitioner was placed in a far better financial position vis-a-vis the 15 numbers of candidates selected for such benefits. Full stop. He further submits that the earlier scheme has now been discontinued, and as per the new scheme, compassionate family pension is paid in lieu of any compassionate appointment. Full stop. It is the objection of non-joinder of necessary parties have also been taken by citing that the selected candidates have not been arrayed as party respondents. Full stop. It is also pointed out that the averments made in the counter affidavit has not been denied by the petitioner by filing any rejoinder affidavit. Full stop. Para. Sri Deka, the learned counsel, in his rejoinder has submitted that the consideration of the candidates was in view of a scheme which was in operation from the period 18/2/2014 to 31/3/2017, and the action of clubbing of all the candidates itself was not proper. Full stop. He reiterates that the financial position of a family should not be taken as a factor while deciding the entitlement for appointment on compassionate ground. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. It is a settled law that an appointment on compassionate ground is an exception to the general rules of recruitment, wherein a benefit is given to an incumbent of a family which has lost its sole breadwinner. Full stop. The objective of such appointment is to enable the bereaved family to overcome the immediate crisis. Full stop. In the instant case, it is not disputed that the APDCL had a compassionate appointment scheme of 2014, which was for the period 18 to 2024, 18 to 2014, 2022, 31/3 to 2017. Full stop. The death of the father of the petitioner being on 22/3/2017, comma, his case was to be covered within the effective period, full stop. The question therefore arises as to whether there was a consideration of the case of the petitioner for such appointment at all, and if so, whether such consideration was made by taking into account all the relevant factors vis-a-vis the similarly situated other candidates. Full stop. Para. Though an objection has been raised on the veracity, public authenticity of the documents, which contains the consideration of all the candidates who were in the fray FRAY for appointment on compassionate ground, comma, in view of the affidavit filed, comma, such objection is not accepted. Full stop. The court is therefore left to examine the consideration done to the petitioner vis-a-vis the other candidates. Full stop. The column containing the remark of the selection committee for each of the candidates would reflect the factors which were taken into consideration. Full stop. Though the learned counsel for the petitioner may be right in contending that payment of family pension should not be a factor to completely negate an application for compassionate ground, comma, the said factor cannot be held to be wholly irrelevant in such consideration. More so when the financial position of the candidates in fray are to be assessed. Full stop. In the instant case, comma, the amounts received by the candidates whose candidatures were considered would show that it is not only the petitioner, but there are other candidates who were held to be ineligible for such appointment, and such finding was mainly on the ground of they being placed in a much better financial position than the other candidates. Full stop. The aforesaid consideration, comma, in the considered opinion of this court cannot be said to be irrelevant or extraneous, as some yardsticks have to be taken in view of the limited number of vacancies. Full stop. If vacancies were existing to accommodate all the candidates, comma, the matter would have been different. Full stop. This court is of the opinion that the rejection of the petitioner from of his claim for compassionate appointment on the ground cited cannot be said to be arbitrary or unreasonable. Full stop. Para. In view of the above, comma, this court is not in a position to grant any relief to the petitioner, and accordingly, the writ petition is dismissed.
Obligement.
Deep.
20, I didn't get you.
For order dated April 23, record was directed to be produced. Report is not important, otherwise the SLC is attached with the reputation. Which shows that due to grant of there are 28 number of vacancy. Have to consider 5%, 28 into 5 divided by 100 is 1.4. That is only one post, one post was there. And for one post, Rotom Factoria was being appointed because the date of decrease of Rotom Factoria is senior, is earlier than that. The second thing is the date is the date of death is on 2013. So the process expert is judgment that whether the urgency is still there.
Selected candidate has been made party.
No, Lord. No, we are not on that, your Lordship. No. They, so far the report, Lordship, is the page 28.
28.
28, Lord. So, but the total cadre strength of the grade 4 post is 50, your Lord.
Yes.
And the appointment on compulsory ground is not made against, and I get 450 number of cadre sector on. And they have, while considering the case of the petitioner, they have taken into consideration of only the post of Khalas, your Lord, keeping aside the other cadre of Gate 4, your Lord.
How many vacancies are there?
3.
3 vacancies are there. No. How many vacancies are there now presently?
So far, the post order is there, one post is directed to be kept.
Yes, what is it?
Lordship,
Total strength is 50.
Lordship, no. Lordship, may kindly see page 42, Lordship, the affidavit filed by the executive engineer, Lord.
42.
42.
Yes.
Khalasi, Lordship, 22 posts, already one person has been appointed, Lord.
Yes.
So, Lordship, what happened? The peon, chokidar, helper and APP were clubbed together and vacancy position come 22. In that post, Lordship, the other person has been appointed, Lord. So he could not be considered. Lordship, may kindly see the peon 4 vacancy position 4. Here is vacancy, Lordship. Chokidar 4, helper 4, and APPO 10 comes 22, Lord. So out of that 22, Lordship, one post.
Total, how many posts have been filled up under compassionate ground? 2 posts.
2 posts.
One earlier and presently the other.
Presently the petitioner.
And total out of, if you hold 50 to be the cadre strength, 5% will be how much? 2.5.
2.5.
Huh? 2.5. 2.5, can you consider 2.5 to be 3? It has to be more than 2.5. And how, okay, the selected candidate is not a party.
Not a party. That is explained in page 35.
In the inter se consideration between Mr. Mohan's client and the selected candidate, what did you look into?
The selected candidate's father died earlier, Lord. It is the only. mentioned in the affidavit.
What did your father do? What did the father of the petitioner do, Mr. Mohan?
Lordship, he was working as a Khalasi lord.
Khalasi. And the private respondent's father?
Lord, your lordship,
It was not lordship reflected anywhere, Lord.
second assistant.
Anyway, Lord, he has not challenged this election, Lord.
No, just
Just
as a matter of concern, we are asking. Without hearing him or without he being a party, we will not touch that.
Yeah.
That will not be fair.
So for the person they have projected, it is Ratan Thakuria, lordship will find page 30 here. He
Which
was
zero?
Lord,
Which person?
page 30 your lordship, last number 3.
Which zero?
What?
Yes. What?
Last bottom number, cell number 3 your
Ratan
lordship.
Thakuria. Hmm.
He was recommended against the post of peon your lordship.
Hmm. What is your name?
My name is Minal Das.
Where are you?
next, page 31.
Recommended
Page 31,
LP for appointment. See, there would be a difference between two situations. One situation is that there is no vacancy at all, where 5% can be
Accommodate.
considered. And there is the other situation where vacancies are there, but the number of candidates are many. So you have to compete. That may not amount to a situation of no vacancy. You had competed. If there is no scope of any competition, even you are not considered for a single vacancy, then one-time consideration is a must. But here you had faced a competition. Somebody succeeded. You were left out. That may not amount to a situation where you are not considered at all. Consideration and rejection is one matter, and one matter is rejection without a consideration. That we will not allow. We want a consideration on a vacancy where there has to be a competition.
But property between minute is it is erroneous because they are not taking into account the entire characteristics of 50
No,
year old.
2.5. No, even if we take your case, we don't take Mr. Upadhyay's case. We take 50 as the cadre strength. 5% of 50 is 2.5. 2 have been appointed already. 2.5 can you construe as 3? Doubtful. It has to be more than 2.5, 2.6, 2.7, anything. You can construe to be a whole number. 2.5 making it 3 would be slightly doubtful.
First, you can fix the matter on next week. I'll satisfy your call.
What is there to satisfy? We have applied our mind. Yes, heard. Sri L. Mohan, Learned Counsel for the petitioner. Also heard Sri N. Upadhyay, Learned Standing Counsel Irrigation Department,
1 and 2, Lord.
whereas
1, 2, and 5.
Irrigation Department,
Lord,
whereas Sri C.K.S. Barua, Learned State Counsel appears for the other official respondents. Full stop. The issue is towards a claim for appointment on compassionate ground. Full stop. Para. The facts projected by the petitioner is that his father, Karuna Das, was working as a Khalasi in the establishment of the executive engineer from a Guwahati division, within bracket irrigation, who had died in harness on 19/1/2013. Full stop. The petitioner had accordingly applied for appointment on compassionate ground. Full stop. Please have your seat, Mr. Mohan. Have your seat. The district level committee, Kamrup, wide its minutes of meeting held on 14/11/2017, had recommended the case of the petitioner for consideration by the state level committee. Full stop. However, the state level committee in its meeting held on 15/9/2021 had rejected the case of the petitioner on the ground that vacancy under grade 4 was already saturated, SATURATED, in the concerned office. Full stop. The petitioner having failed to get any relief from the respondents in spite of representations had filed this writ petition on 30/11/2021. Full stop. Para. Sri Mohan, the learned counsel for the petitioner, has submitted that the grounds of rejection of non-availability of 5% of the vacancy meant for appointment on compassionate ground is erroneous. Full stop. By drawing the attention of this court to the staff position of grade 4 in the concerned office, the learned counsel has submitted that the total cadre strength is 50, and therefore the reasons assigned is not sustainable. Full stop. It is submitted that the petitioner could have been easily accommodated, more so when his case was duly recommended by the district level committee after consideration of all the facts and circumstances. Full stop. The learned counsel accordingly submits that appropriate directions be issued for consideration and appointment of the petitioner on compassionate ground. Full stop. Para. Sri N. Upadhyay, learned standing counsel, Irrigation Department, on the other hand, has submitted that even assuming that even if the projection made by the petitioner regarding the total cadre strength is accepted, the 5% vacancy would not be enough to accommodate the petitioner, inasmuch as 2 posts are already filled up on compassionate, are already filled up by candidates on compassionate ground. Full stop. It is further submitted that the right for compassionate appointment is not a vested right, and such right would only extend to for a fair consideration, which has been done, as would be revealed from the minutes of meeting of the state level committee. Full stop. Para. Sri C.K.S. Barua, the learned state counsel, while endorsing the submission of the standing counsel of the department, has further submitted that the factors which were taken into consideration by the state level committee are relevant and germane to the and the same would not require any interference by this court, full stop. The London State Council has also raised the objection that the selected candidate, one Ratan Thakuria, has not been made a party respondent, and therefore any orders that may be passed for consideration of the case of the petitioner would adversely affect the said incumbent without affording him an opportunity of hearing. Full stop. Para. The learned counsel for the petitioner has, however, clarified that he is not against the consideration of the incumbent who has been appointed, and only prays for a fair consideration of his candidature vis-a-vis the vacancies existing. Anything?
Not to be in para 4 of the affidavit, they have not indicated anything about the appointment of consideration of the Ratan Thakuria against which against which vacancy. That is why order dated 20th 5 will may kindly have a fair.
He has also submitted that the affidavit filed by the respondents does not disclose the details of such consideration of the said incumbent. Full stop. Para. The rival submissions have been duly considered. Full stop. The minutes of meeting dated 15/9/2021 of the state level committee would indicate the grounds of consideration of the case of the petitioner, as well as that of the incumbent who has been given the benefit of such appointment. Full stop. It is not a case where the case of the petitioner did not come up for consideration at all due to want of vacancies. As full stop. If in a given case wherein consideration cannot be made at all, comma, it is seen, and this court has been passing consistent orders holding that one-time consideration is a mandate. Full stop. The difference in the present case is, however, that a consideration was indeed made for an available vacancy in which the inter se merits of the petitioner and the incumbent who has been appointed was made. Full stop. The state level committee has cited reasons for giving the benefit of appointment to the incumbent who, however, has not been made a party, and so far as the petitioner is concerned, comma, an observation has been made that the vacancy of 5% has already been saturated. Full stop. Para. As regards the cadre strength of the grade 4 post, comma, it is seen from the list annexed in this proceeding that the total cadre strength is 50 and 5% would be 2.5. Full stop. Since 2 appointments two persons have already been appointed under the aforesaid ground of compassionate, under compassionate ground, comma, a third appointment may not be permissible, as the minimum vacancy for a further consideration has to be more than two. Full stop. This court has also been apprised of a recent decision of the Honorable Supreme Court in the case of State of West Bengal versus Debabrot Tiwari, in which the following has been laid down. Full stop. Para. It is settled that it is a settled law that an appointment in compassionate ground is an exception to the general rule of recruitment, wherein a benefit is given to a bereaved family which has lost its sole breadwinner, so as to enable to overcome the immediate crisis, and the same loses its essence by elapse of time, efflux of time, full stop. Further, comma, the right is only limited to a fair consideration, and there cannot be an indefeasible right for such appointment. Full stop. In the instant case, comma, this court finds materials on record that a fair consideration was indeed made, whereafter the candidature of the petitioner could not be accepted. Full stop. Para. In view of the aforesaid decision, comma, this court is not in a position to grant any relief to the petitioner. Full stop. The petition accordingly stands dismissed. Yes, madam.
Lordship, second petition, so far as second petition is concerned, 2 weeks time may be granted to file my reply.
You filed affidavit in opposition. You for whom?
I forgot the first one, 7 to 6.
7268. You filed affidavit.
Yes.
File affidavit.
7268. You have filed affidavit. Rejoinder also.
No.
And
They have filed a simple affidavit. Any dispute arising about the rule, the government decision will be the final. There is
okay.
any-
And government.
And
I'm a bit
second affidavit. So far as his affidavit is concerned, I want to file affidavit.
No, there are two writ petitions, madam.
It's
7268 is the first writ petition.
Right.
7307 is the second writ petition. We find that affidavit in opposition has been filed in the first writ petition.
Lordship.
Will you like to file rejoinder in the first
No,
writ petition?
no.
No.
In second.
Second also you filed affidavit.
Yes, ma'am.
Okay, we'll say, Instructor
7307.
P. Bora,
Lordship.
Ms. P. Bora, learned counsel for the petitioners. Pray for and pray for and is granted time to file rejoinder affidavit in this
Two
case, in these cases. Wherever you find it. List after 3 weeks.
Obliged.
23.
May I please? The last time BTC active to take any staff regarding the vacancy position, which was mentioned in the DLC with 29/10/2007.
Yes,
Your Lordship, we have very recently received Paraguay's comments, Your Lordship, but the details in the instructions does not contain clarifications regarding the
vacancy.
relevant point.
It is that
So
point,
some time may be given, Your Lordship, to
it
clarify.
is only that point we require your instructions.
That's it.
Okay, you get the instructions. But this is a matter of 2000 what, 19? 22.
Date occurred in 2007.
Hmm?
The date occurred in 2007. So say that it's important. The government took it.
11 deaths.
Yes, sir. 9/4/2011.
Number 7 of the date. There are number
Yes, what is your right? After 2011 in 2024.
Yes, but my career was considered against the vacant post law, 2020, 2011 law.
Now, can we direct for a compassionate appointment after 13 years?
Subsequently, 2020 also rejected. This is second time later, second time.
Understood, but can we direct an appointment on compassionate ground after 13 years?
The notification dated 1/6/2015 lordship close 15 lordship. Maybe get part of the considered.
Now, after 13 years, where is the scope to make such a direction?
This is the part of the respondents that delay law.
Even that has to be taken care of. Delay, that is the harsh reality. Even delay on the part of the authorities would come into consideration. Eleven deaths, 24 direction, not possible. What are your instructions? What is your name?
Each of my, Your Lord.
You are for whom?
SR Rabbi, Your Lord.
BTC?
Yes.
What are your instructions? Where is the DLC recommendation?
I have not, the last that I have provided.
Hmm?
Has not NS lordship, but I submitted last.
You don't have the DLC recommendation. What is there?
It's the recommendation of Mr. Proxy. 29 May 2011, the Proxy, the Brahma was recommended. Just one post for it. Recommended against the second post of get and evidence grade B and BS. That time for the there were one post again.
Let us have a look. You may not be able to grant your relief. Was meeting, you know. We'll have to rise now, but we'll close this. We'll pass orders today itself. There's a meeting. नाम तो लिख रही हूँ. You're GU Ahmed.
Yes, sir.
GU Ahmed. One. What Chakma you said?
T Chakma, Your
T Chakma, BTC. Then CKS Barua, State Council. N Kolita for A Kolita, Industrial and Commerce Department. It will.